have had a good say now. I apologize for the heat outside, but that's an expression of the warmth towards CEPEJ. We tend to be a bit tired, so we are a bit too hot outside. Apologies for that, but I'm sure we will try to do it as best as we can. I would like to welcome you all over here and allow me to start a few words to you all. It is with great pride, and I must admit with a slight dose of trepidation, welcome you all to the 20th anniversary celebrations of the European Commission of the Efficacy of Justice, which is better known to all as CEPEJ. Indeed, it is an honor for my country, Malta, being a place where throughout centuries, so many diverse cultures and people have chosen to flourish, to host this important international which, whilst celebrating the great achievements that CEPEJ has attained through the years, looks forward towards the new challenges being faced by justice, embracing the developments of digitalization in the and challenges of the judicial world. I want to start, if you don't mind, by thanking the government of Malta, represented here by the Minister of Justice, for having hosted this press activity in our capital city, Valletta. And would like to thank also to thank all those involved in the operation, especially those who are currently hiding or running around within the department, starting from Joanne Battistino, desperately trying to get everything organized, but believe me, she really got everything as organized as could be, who has been instrumental, together with her colleagues Paul, Katrian, and Jeremy. I would really like to thank you all, because this would have not been you. CEPEJ, from its creation on the 18th of September 2002, the Committee of Ministers adopted Resolution 12, has been a beacon to all, providing a vast array of tools and instruments, as well as opportunities for further cooperation and development to all those willing to promote the rule of law, so as to ensure fair, efficient, and accessible judicial systems are available to all citizens of our states. CEPEJ, through its endeavors, helped by the valid contribution of many hard-working, like-minded experts throughout the 46 states which compose the Council of Europe, as well as from beyond, has throughout the years produced groundbreaking reports and tools which have become essential, allow me to say, not only amongst the member states, but even worldwide, both to understand the different judicial systems, as well as to facilitate the efficiency and fairness of the evaluation of judicial systems report, which is considered a reference point all over the world, and which will soon be in its 9th edition, very ably managed by the Evaluation Working Group together with the Secretariat of CEPEJ, has allowed all to garner a better understanding of the various judicial systems we all embrace, creating a platform of comparison intended to exchange our knowledge of the various systems, learning from one another and focusing on how to improve quality and effectiveness of justice. The checklist of promoting the quality of justice, adopted in 2008, is the first in a list of tools and guidelines, too long to mention, which throughout the years the Quality Working Group have discussed and drawn up, and which have proven to be instrumental to many court administrators and users to further the quality of justice. The adoption of the European Charter on the use of artificial intelligence in judicial systems way back in 2018 was a milestone in CEPEJ's journey. This being a charter masterfully piloted by the Quality Working Group, which identified 5 main principles which should apply when considering the use of artificial intelligence in the judicial systems. The charter, allow me to say, has been recognized worldwide and is considered to be a reference point to all when considering the use of artificial intelligence in justice. The time management checklist adopted in 2005 proves to be the first of many valuable tools and guidelines which the Working Group on Judicial Time Management, also known as Saturn, not the planet Saturn, Saturn, has churned out throughout the years, which tools have proved to be essential for court users to better understand the processes of justice and render them more efficient. The adoption of the Case Weighting in Judicial System report in 2020, whilst in the midst of the pandemic which blighted the whole world and brought it to a standstill, that was the pandemic, is testament to the strength and will of CEPEJ to keep on providing important tools to better assess and improve judicial systems, not only ours, but everyone's. In recent years, the developments of IT has led to the creation of the Cyber Justice Working Group in 2020, which group, though relatively still young, has already produced very valid and useful guidelines, such as on video conferencing in judicial proceedings and digitalization of courts, which in themselves are part of the building blocks of what we are going to discuss today, the digitalization of judicial systems. We are now living in a world where virtually everything is done digitally, from ordering a pizza or getting a taxi to come to the conference, in your tax forms, and filing all the relevant documentation. It is therefore inevitable that digitalization will reach the shores of justice. And in actual fact, allow me to say, I think it has already reached our shores, if not inundated them too. We therefore have to ensure, as CEPEJ, to strive to provide necessary tools and instruments, as well as opportunities of exchange of ideas, for the various court users, so as to be able to both protect the principles of human rights as set in the Convention, as well as to promote the fair, efficient use of digitalization in our justice system. I am convinced that with the interventions of all the learned and the esteemed contributors to the conference, this will help CEPEJ to further its objectives and set its goals towards the future of an efficient and effective justice. Now, I will proceed to open the conference, which I have already done, but I'm repeating it again for whoever hasn't noticed. And I believe that now we will have some words to General, Madam Pecinovic-Buric, who, though unable to attend, was kind to share a few words with us on this occasion.
Ministers, distinguished experts, jurists, and guests, ladies and gentlemen, for 2 decades now, CEPEJ has played a central role in upholding individuals' fundamental rights. The European Convention on Human Rights, ratified by every Council of Europe member state, guarantees the right to a fair trial within a reasonable time and the right to effective remedy. Ensuring this is vital to exercising all of the other rights and freedoms laid out in the. So it is vitally important that national justice systems are marked by quality and efficiency. In the first instance, it is the responsibility of member states themselves to ensure this. But they must not be left without help. Among the range of mechanisms at their disposal, CEPEJ is of central importance, identifying individual problems and trends and supporting national authorities by the guidance and practical tools needed to implement reform. Over the past 20 years, CEPEJ has gone from strength to strength. It has provided a wide range of in-depth analysis based on extensive data collected, collated, and examined by leading experts. The 10th evaluation of European judicial systems is a case in point, and I hope that CEPEJ will adopt it at the plenary session. But it is also important to note the wide range of work that CEPEJ produces in support of those who use Europe's strengths and the professionals who work. This is clear from the tools produced by its groups and used in cooperation projects with member states. In recent years, These have included guidelines for communication with the media and the improvement of judges' skills and competence, and on the centralities in civil proceedings, to name just three. CEPEJ regarde aussi vers l'avenir. La réalisation des technologies numériques pose de nouveaux défis pour la qualité et l'efficacité de la justice. Défis que les changements dans les méthodes de travail entraînés par la pandémie Covid-19 ont rendu plus pressants. Dans ce contexte, les travaux de la CEPEJ sur la tenue d'audience par référence et sur la numérisation des dossiers judiciaires importants, tout comme le soutien qu'elle apporte aux États pour les accompagner dans la numérisation de leur système judiciaire. De même, vu la place prise à l'intelligence artificielle et que ne fera que s'étendre, la charte éthique européenne élaborée par la CEPEJ est conjuguée à son programme d'activité, à son plan d'action sur la digitalisation pour une meilleure justice, centre de ressources et à son comité consultatif sur l'intelligence artificielle et la cyberjustice. Elle offre un ensemble de ressources essentielles qui permettra à nos États membres de et de s'ouvrir à un avenir placé sous le signe des technologies. Bien sûr, d'autres problèmes connus de longue date continuent de se poser. De nombreux sont toujours prises avec le problème de la longueur des procédures, aussi bien en matière que pénale et administrative. Ce problème s'est encore aggravé avec la crise sanitaire que nous venons de traverser, qui a ralenti le rythme de traitement des affaires. Mais que nous parlions de anciens ou plus récents, la CEPEJ a fait la preuve de capacité à apporter son soutien, s'adapter. Pas un instant qu'elle continuera sur cette voie et que la justice en sera plus forte. À l'heure où nous fêtons cet anniversaire important, j'adresse donc félicitations à toutes les personnes qui contribuent à l'action de la CEPEJ.
I would like to thank the Secretary General for her lovely words. And whilst we miss her over here, we send her our very best and look forward to seeing her one day in Malta. Now I invite the Minister of Justice to give us a few words, please. I didn't take the podium. I tried to keep myself low-key.
Secretary General of the Council of Europe, President, Honorable Mr. Justice De Pasquale, Honorable Ministers, distinguished experts and guests, jurists, ladies and gentlemen. Good morning, first of all. Before I begin, please let me welcome you to this 16th century capital city Valletta. And I welcome those of you who have traveled to Malta, especially for this conference. We are pleased to see you. I hope your stay is proving to be enjoyable despite the extensive warm temperature, and will return. It's a pleasure to address you on the occasion of the 20th years of the CEPEJ. During the past 20 years, the CEPEJ has played an important role, not just in every member state, but also in the international field. It serves as a guiding forum that connects us all. Justice should neither be delayed nor denied, and in order for this to be done, we need to ensure that all projects undertaken with the aim to enhance the quality and efficiency of are measurable, since whatever is not measurable is, generally speaking, not worth pursuing. It is for this reason that I hereby wholeheartedly thank CEPEJ and hence all of you hereby gathered today for your work in this regard, exchanging knowledge and good practices in areas dealing with the efficiency and digitalization of our justice system, it is to be encouraged and further fostered. This does not only create healthy networks, but also inspire new ways of proverbially reaching the center. We are committed to continue enhancing set exchanges and building our networks and bridges to learn from one another's experience. Already underlined in the introductory speech by the Secretary General, quality and efficiency of national justice system is of the essence in any functioning justice system, whilst ensuring that the national legal systems and traditions are respected. CEPEJ's support towards national authorities in their pursuit to enhance the national justice system is of vital importance. This government, under the leadership of Prime Minister Robert, is committed and fully determined to continue on its pathway in attaining this goal. As retained in the electoral manifesto, this government is committed to addressing the efficiency of justice by implementing new landmark reforms. These reforms include major amendment process, the committal proceedings, and the appeals procedure, which both are intended to address the problem of the delays that have over the years. Furthermore, government will continue to invest in the infrastructure and human resources to achieve the best possible result and ensure that justice is not only done, but manifestly and undoubtedly be seen. In order to continue enhancing the national justice system, government is also committed to facilitating the transition to a more digitalized justice environment. This is being done through the recently launched digital strategy, which strategy shall be achieved through the gradual of the business processes in the justice sector. We want a system that is digital by default, whilst ensuring that all citizens and legal professionals have access to justice and legal informative of one's level of IT literacy. The digital justice strategy in and of itself also continues to cater for the building and improving the digital skills and competence of the judiciary as stakeholders within the justice sector. In the coming months, the Justice Ministry will be rolling out several initiatives within this own consultation, and all aimed to facilitate the access to justice. We believe that training members of the judiciary is the sole backbone of a strong, effective, independent national justice system. In fact, apart from providing the necessary training, we are also looking into introducing the use of artificial intelligence to assist the judiciary in analyzing documents and court decisions. We are committed to see this through in order to further enhance the of our national justice system. In terms of its independence and in line with the January 2022 Eurobarometer surveys, over 7% of the general public and over 65% of companies consider the more judicial institutions to be independent. This marks a notable improvement in public and industry perception of judicial independence over the previous year. This is also as a result of a number of reforms undertaken over the past few months, rendering the appointment procedures of all members of the judiciary, including justice, even more independent and severed from any linkages to the executive. By way of conclusion, let me once again thank you all for your tireless work in making national justice system more efficient and hence offer higher quality to all justice. I would also like to access to the organization team from the Office of the Permanent Secretary, namely joined by Stino, Paul Parch, Katrina Rizzo, that worked tirelessly in organizing this conference. And on a personal note, I would also like to thank Mr. Francesco De Pasquale for his hands-on approach and putting to work to push forward the digitalization both locally and internationally. For me also take this opportunity to wish a happy 20th birthday.
I'd like to thank the Minister for the lovely words. I think we have a birthday present for CEPEJ, to give presents for many things. And, the 20th anniversary is something that is something important. And it would be nice if we present a gift to CEPEJ from Malta. And I don't know whether we can invite the artist, Mr. Chefai. The painting is down there. Yes. Shall we put it here, Joe, please? Or else you can go over there. I invite Ramin, the President. Unfortunately, I always refer to him. And the Minister. And I will let them run the show down there. The halls, down there. Maybe you can see it here, I don't know. Okay.
I was asked to explain the whole idea. The world of what takes you in a lot of places. I would have never imagined that I'd be addressing such a conference like this. So excuse me a little. I'm a bit excited about all this. But basically, when one talks about digitization, etc., it's very difficult to try to imagine how you can portray something like that artistically. Not that the world is far off from the arts. It's partial nowadays. But talking about digitization and efficiency, I realized that the whole idea is not about technology at the end of the day, but making justice real and more present in people's life. I'm a citizen, and for me, digitization is important because it makes things accessible, like everything else, filling forms, filling whatever it is. When I was researching about the topic, by chance, I realized the old Maltese prison and courthouse, which is the Castellania, which is today used for health. There are two allegorical representations of justice, and I think prudence and justice remain very, very relevant, and allegorical personification remains very, very relevant, because what if we are used to see dressed in classic robes, etc., are just two normals sitting down having a chat. And I see justice important in that aspect, that it relates to the everyday person rather than big discussions that you may be discussing. And for us who are on the other side of justice, it's the little things and the everyday life that and the young girls, which look at the future as well, are exactly that. The allegorical personification, what justice can be today, but also in 20 years' time. So that is at least my personal interpretation of things. And where there's a little bit of darkness, you find justice and prudencia that are present. So, thank you.
Thank you very much. Just a few words. Thank you very much. This will memorize this 20th anniversary on behalf of all members, to thank you for your job. Just one amendment, the other side. We are here just to serve for citizens. The idea is to improve if there is need for improvement, to make it more efficient. It means we served for you. We served for the citizens, legal entities. It's the main idea, and thank really, I was touched. So, and thank for on behalf of everybody and Minister's initiatives. Really, it's much.
So, for the detailed idea behind it, I'm sure we will be enjoying offices of CEPEJ every now and then and bumping into the painting and saying, that is it. Maybe in 20 years' time, I'll come with, we'll walk and do like that. So, at this stage, I will invite Mrs. Buckley, the Deputy General of the Department of Justice of Ireland, who has honored us with, and I welcome her here.
Thank you very much, Francesco, and good morning, everybody. Dies Mora Grieve. I'm afraid I'm bearing gifts. I suppose the largest gift I have was I managed to navigate the European air traffic situation at the moment to make it as far as Malta, which was quite an interesting experience for myself and my colleague who are here today. But I'm pleased to be here in my first visit to Malta. And so really very pleased to be here, both representing the Presidency of the Council of Europe at the moment, and to and thank the Commission for the Efficiency of Justice, CEPEJ, for inviting me here today as we especially significant occasion of its 20th anniversary. In the 2 decades since establishment, the Commission has worked to protect and promote human rights and law for the proper functioning of justice across the member states of the Council of Europe. CEPEJ supports a simple premise that for the rule of law to function well in any country, it must be the access to effective dispute resolution. And recent developments in digital present real opportunities to improve the quality and efficiency. At the same time, however, as the Commission rightly points out, they constitute new challenges for the respect of the fundamentals of the trial and the essential guarantees of our judicial systems. CEPEJ is at the forefront of ensuring that this balance is maintained in a way that safeguards fundamental human rights and ethical considerations. The Committee's Action Plan of 2022 to 25 sets out how it plans to accompany states and courts in a succession towards digitalisation of justice over the years in a way that ensures justice is humane, efficient and of high quality. Central to CEPEJ's commitment to providing enhanced information relating to its evaluation of judicial systems and other tools to promote better understanding and widespread application of those results. Also of key importance is CEPEJ's adoption of the first European text setting out ethical principles relating to the use of artificial intelligence in judicial systems. This innovative text sets out the guiding principles for the development of AI tools in European judicial systems with the clear goal that they service the general interest and that their use respects individual rights. The Working Group on Cyber Justice and Artificial Intelligence has been tasked with developing tools and training programs that will facilitate these goals. And I look forward to seeing their work implemented in Ireland and in other countries in cooperation with the work of other Council of Europe bodies in this field. On the 20th of May, Ireland was privileged to take up the presidency of the Council of Europe for the 7th time. Our 6th-month leadership of the continent's leading human rights organisation comes at a critical point in European history. On the 16th of March, shortly after the invasion of Ukraine, the Council became the first multilateral organisation to expel Russia. Responding to the consequences of the extraordinary events of the past few months is naturally a priority for Ireland's presidency. The invasion and subsequent expulsion of one of its largest member states has been a period of adjustment and challenge for the Council as it responds to the war by bolstering support for judicial and democratic institutions in Ukraine and human rights protection for Ukrainians across Europe. It, of course, also means that member states are being asked to contribute more to cover the shortfall for the next 2 years before other financing models are considered by them. The Irish presidency is adopting a whole-of-government approach to the Presidency of the Council of Europe, focusing on three key themes. Firstly, our founding freedoms, reinforcing human rights and the protection of civilians in Europe. Secondly, hear our voices, promoting participatory democracy and youth engagement. And lastly, Fáilte, which is a Gaelic word for welcome, fostering a Europe of welcome, inclusion and diversity. I feel this last is particularly important and poignant at a time when Ireland and other European member states, that water is quite precious, I wouldn't be throwing it away as with that. And other European member states stand in solidarity with Ukraine and welcome with open arms those fleeing the war. Working with our European partners, we will continue to play our part in assisting it in their time of greatest needs. Ireland's Taoiseach, or Prime Minister, recently visited Strasbourg, and our President, Michael D. Higgins, who of course was also recently in Malta, is also expected to address the Council of Europe's Parliamentary Assembly over the 6-month term. Our permanent representative in Strasbourg, Breffney O'Reilly, will chair a dozen meetings of the Committee of Ministers, addressing the Council's work on a wide range of issues, such as civil society and youth participation, media freedom, and gender equality. And in September, our Minister for Justice, Helen McEntee, herself a woman who's breaking significant boundaries in Ireland by being the first woman to take maternity leave while a minister, she will convene an informal meeting of the Council's 46 Justice Ministers in Dublin in September, devoted to combating domestic, sexual and gender-based violence. And I hope very much that the countries here represented can participate in that conference in the autumn. I can promise it will be cooler than in Malta. Ireland's presidency will also place an emphasis on human rights and the environment, and on equal access to a healthy environment across all member states. And at April, Ireland aims to progress a recommendation on human rights and the environment at the Council of Europe, scheduled for adoption by the Committee of Ministers in late September. Support for this recommendation is consistent with Ireland's co-sponsorship of UN Human Rights Council Resolution 48 of 13, which recognised having a clean, healthy and sustainable environment as a human right for the first time. The digital focus theme of this conference, I'm proud to say that Ireland is in the midst of an era of modernisation and innovation across our justice sector. CEPEJ is 20 years old. The Irish court system is 100 years old. And its needs for reform action are perhaps significantly greater than those who have had at times to reform your court system. So under the stewardship of our Minister for Justice, Judiciary and the court system, the Irish government is investing significantly in our court system, with a number of major reforms underway that we hope will lead to quicker, easier and cheaper access to justice for all in Ireland. A wide-ranging administration of civil justice was published in 2020, containing over 90 recommendations, and implementation of those proposals will represent the most significant reform to civil law in the history of the state. Last Minister published a plan which sets out specific actions, phases and target dates for completion of these actions up to the end of 2024. And I'm pleased to say that 6 of them have already been completed. Changes to our rules of court to encourage compliance with time limits to help reduce delays. Key actions include the promotion of video of an online information hub to provide dedicated legal and practical information for those considering bringing proceedings without professional representation, in other words. Substantial progress has already been made on the increased use of video conferencing across courtrooms, and while COVID was very negative in many ways, at least that we couldn't meet in person as we are here today, in one way at least it has been very positive. It cleared a lot of the barriers away from the increased use of digital means within our court system. And towards the end of 2020, the Court Service commitment in excess of 2.2 million to expand the number of courtrooms enabled. These courtrooms support remote and hybrid hearings and allow witnesses, prisoners or police dial in remotely to a physical courtroom and support digital evidence display. Another digitally enabled advancement in a court environment in 2020 was the introduction of a remote hearing platform where things can be heard with no in-person attendance at a physical courtroom, allowed for judges, court service staff and all parties to participate entirely remotely via video link. And this is significant long-term to remove the overhead of in-person appearance, particularly for procedural sittings, which are a major feature of the Irish court system. We're committed to driving the modernisation and digital-first agenda sector, and particularly welcomed the commitment set out by the Court Service in its corporate strategic plan to maximize the use of digital technologies and provide an service. And we're going to continue to accelerate the digitalisation of our courts to ensure that justice is accessible for everyone. And it's also a priority for our Minister to ensure that the courts to administer justice efficiently and effectively. In order to bring more strategic focus to this, she established a planning working group in 2021 to consider the and type of judges required to ensure the efficient administration of justice over the next 5 years. The report and recommendations of this group will any future judicial resourcing needs. In a democratic society based on the rule of law, plays a central and independent role in how justice is administered. It is critical, therefore, that the process to appoint members of the judiciary is transparently based on securing the best people for those roles and that they are enforced in their careers. In April, the Minister published the Judicial Appointments Commission Bill. When enacted, lead to the biggest reform in the way judges are chosen for, certainly in a quarter of a century and possibly over the entire lifetime of the modern court system in Ireland. The Commission, which will comprise an equal number of lay representatives, will recommend candidates for judicial appointment to the Minister for Justice and for the state, such as the Minister of Justice, to the Foreign Affairs. Those recommendations will be based on merit. And in a change from current practice, any person wishing to be considered for appointment to judicial office, including judges, will be required to apply to the Commission. It also provides that all candidates will need to have undergone an interview before being recommended to the Minister, which is possibly the most innovative part of the rest of all. Interviews before appointment, who would have thought it? The Minister is also determined to overhaul the family justice system into one that's focused on meeting the common of all who engage with it. In 2020, she established an oversight group to direct and oversee the development of a strategy to design this reform. And at the same time, there was publication of a general scheme of a family court bill. And the purpose of legislation is the establishment of, I grant you, a very overdue, dedicated court in Ireland to improve levels of judicial expertise and training in family law matters and to streamline proceedings, thereby making them more user-friendly and less costly and less traumatic for everybody involved. Drafting of the bill is ongoing with a view to its publication as soon as possible. Thank you for indulging me and allowing you to tell you a little bit of what's happening in Ireland. But in closing, I want to thank you again for CEPEJ and for all of the team for inviting me here today to mark this milestone, to acknowledge the incredibly important work being done by CEPEJ. Ireland, with its venerable court system, knows that as much as any. We need the help of CEPEJ to help us improve and reform. And for our part, the Irish Government of Justice will continue to work tirelessly to improve efficiency, access and effectiveness in our justice through the reforms and initiatives in our Programme for Government and the Minister's Justice Plan 2022. And we hope to work closely with CEPEJ in delivering on this. Thank you very much for your kind attention.
I want to thank you very much for this very interesting insight into the various, and it is very interesting, and I must admit almost envious in certain things that you have done, and it's very nice. Thank you very much once again. I invite Ambassador Christian Moley, who is the permanent representative of Switzerland, of the rapporteur, the group legal cooperation of the Committee of Ministers within the Council of Europe.
Merci, Monsieur le Vice-président. Monsieur le Ministre, Madame la Secrétaire générale adjointe, Monsieur le Président de la CEPEJ, Mesdames et Messieurs, permettez-moi aussi de féliciter les autres de Malte, et vous en particulier, Monsieur le juge de Pasquale, de l'initiative d'avoir invité la CEPEJ pour cette session d'anniversaire et de les remercier chaleureusement de leur hospitalité et de leur générosité qui va jusque dans l'expression artistique. Mesdames et Messieurs, la sécurité en Europe repose sur la justice. C'est l'Assemblée parlementaire du Conseil de l'Europe qui nous le rappelle dans dans sa résolution votée il y a à Strasbourg sur le rôle du Conseil de l'Europe face à de nouveaux défis que vous avez, Madame la secrétaire générale adjointe, suite à la guerre d'agression de la Fédération de Russie contre l'Ukraine. À l'heure où l'ordre international est violé et où l'architecture de sécurité européenne est déstabilisée, il est important de souligner, comme le fait l'Assemblée, que, je la cite, la sécurité est un concept plus large que la défense et repose dans une large mesure sur le respect des processus démocratiques, des droits de l'homme et de l'état de droit. Fin de la citation. Face à l'approche des relations internationales mues par les sphères d'intérêt consistant à imposer des choix par le recours à la force, l'Europe est la pierre angulaire d'une société européenne et internationale sur la poursuite de la paix fondée sur la justice et la coopération internationale. Presque 3/4 de siècle après la fondation du Conseil de l'Europe au sortir de la Seconde Guerre mondiale, notre organisation comme rempart pour l'indivisibilité de la sécurité démocratique est remise en lumière. À l'occasion du 20e anniversaire de la CEPEJ, cela doit animer nos réflexions. Le penseur libéral Benjamin Constant, que je cite d'autant qu'il est né à Lausanne en Suisse, parlait d'indivisibilité et sécurité démocratique. Le terme n'existait pas à l'époque, mais c'était ce à quoi il pensait, dans son ouvrage politique publié en mai 1815. Juste avant Waterloo, qui mit fin à cette tentative, consiste à faire accepter par Napoléon, le despote auquel il s'était auparavant opposé, une union portant, je cite là, Benjamin, tous les droits de l'espèce humaine, la sûreté des individus, la liberté de la pensée, la garantie des propriétés, l'abolition de tout arbitraire. Et Benjamin Constant écrit « Ses yeux doivent caractériser une bonne justice, à l'inamovibilité des qu'il écrit et à la sainteté des jurys. Il faut réunir encore le maintien constant et scrupuleux des formes judiciaires. Quelque imparfaites que soient les formes, elles ont une faculté protectrice qu'on ne leur ravit qu'en les détruisant. Elles sont les ennemis nés, les airs inflexibles de la tyrannie populaire ou autre. » Fin de la citation. Cette sécurité démocratique, l'Assemblée parlementaire ou Benjamin Constant nous a trouvé aussi au cœur du mandat de la CEPEJ, établi pour améliorer la qualité des systèmes judiciaires européens, renforcer la confiance des justiciables dans ces systèmes et devançant l'innovation. La CEPEJ, depuis 20 ans, a soutenu l'évolution des formes et de la pratique judiciaire vers une capacité toujours meilleure de protéger les libertés, les arrêts de la Cour européenne des droits de l'homme. La CEPEJ est une source d'information comparative, un espace de coopération, également un laboratoire où, en partageant les connaissances, les développements et les expériences abouties dans les États membres. Ainsi que les ministres l'ont souligné, la plus récente réunion, la 132e à Turin, il y a un peu plus d'un mois, contribution de la CEPEJ pour l'indépendance et l'efficacité des systèmes judiciaires s'inscrit dans un ensemble le groupe d'État contre la corruption, GRECO, la Commission de Venise, le consultatif des juges et celui des procureurs européens, dont je salue les représentants ici même, le CDCJ, Comité de coopération juridique du Comité des ministres, est un autre pilier de ce travail interactif au sein du Conseil de l'Europe, sans oublier à l'Assemblée parlementaire le rôle de la Commission et des affaires juridiques. Pour le ministre, la CEPEJ semble être un conseil et une source d'initiative de la plus haute valeur. D'une part, la CEPEJ mène des recherches et des évaluations indispensables pour la transparence, mais d'autre part, elle est aussi à la source d'études et de recommandations utiles, notamment pour la transformation des systèmes judiciaires dans un environnement technologique en rapide évolution, le thème même de la session solennelle. La prise en compte de ces recommandations facilite la mise en œuvre des obligations ou des coopérations découlant d'instruments conventionnels et intergouvernementaux du Conseil de l'Europe dans le domaine de la justice civile et de la justice. Pendant 2 ans, j'ai présidé les débats du groupe des rapporteurs sur la coopération juridique du comité. Parmi les travaux marquants de la CEPEJ pendant cette période, je relève bien sûr les avancées accomplies sur le thème de l'utilisation des systèmes d'intelligence artificielle dans le domaine judiciaire et dans son fondement. Le vice-président, vous avez déjà mentionné de nombreuses réalisations de la CEPEJ. Je me borne à souligner que la conférence des ministres de la Justice réunie à Budapest en octobre 2021, sous la présidence à l'époque hongroise, bien sûr, du comité des ministres, c'est de compter sur l'expertise des membres de la CEPEJ. J'ai plus avant les responsables politiques dans une concertation sur la mise en œuvre et les effets, éventuellement les risques de digitalisation. L'activité du groupe de travail sur la cyberjustice et l'intelligence artificielle se poursuit dans le cadre du programme d'activité 2023 de la CEPEJ, dont le comité des ministres a pris connaissance en début de cette année. La création d'un centre de ressources en ligne dans ce domaine noté, avec particulièrement d'attention. Le comité sur l'artificiel, chargé par le comité des ministres de rédiger un instrument juridique à caractère transversal, sera un instrument de nature d'une convention. Tout l'indique, les États membres s'accordent à lui donner ce caractère. Cet instrument, donc, pour la protection des droits de l'homme face aux risques découlant de l'application de l'intelligence artificielle, peut compter, j'en suis certain, pour son élaboration sur l'appui, sur l'apport de la CEPEJ. Les deux groupes, le comité sur l'intelligence artificielle CAI et la CEPEJ, sont appelés à intensifier leurs échanges pour faire en sorte que les négociateurs comptent des réflexions déjà menées et que les développements ultérieurs au sein s'alignent sur les principes généraux retenus au sein du CAI. Ainsi, avec la vigilance apportée à tous ces travaux, la cyberjuridique ne va assurément pas dériver vers la version de science que Philippe Cadic nous a montré dans The Minority Report, où ressemblait à l'univers qui s'en est le film du même nom avec Tom Cruise. Dans le mandat de les individus, les utilisateurs sont placés au centre des préoccupations, aussi font partie des autorités judiciaires que ceux qui sont des usagers. La transition vers le numérique s'accompagne d'une sensibilisation aux enjeux, aux objectifs visés et d'une information sur les avantages à obtenir. La CEPEJ a ses besoins et énoncé les bonnes pratiques à mettre en œuvre pour que la dimension humaine prévale sur les technologies et que la justice reste transparente. En 20 ans, la justice a changé d'air avec le basculement dans le numérique. Mais le souci de garantir la forme pour contrecarrer toute tyrannie chère à Benjamin Constant demeure primordial, de sorte à lier autorité des juges et protection des libertés pour la sécurité de l'Europe et de ses habitants dans un effort indivisible pour l'efficacité de la justice. Mesdames et messieurs, je vous souhaite plein succès pour les travaux de la session qui va suivre et je vous remercie de votre attention.
I thank you very much for the lovely words you had for CEPEJ, and we will keep on striving on what you have already told us to do. I will now invite the President of CEPEJ, Mr. Ramin Garagburali, while being sensitive that we are running on time.
Dear distinguished guests, dear members of CEPEJ, ladies and gentlemen, it's great honor and pleasure to welcome all of you in the 20th anniversary ceremony of the European Commission for Efficiency of Justice of the Council of Europe. Taking this opportunity of all members of CEPEJ, I would like to express our gratitude to these authorities, especially to the Minister of Justice, for hosting this ceremony, as well as the CEPEJ plenary meeting and their warm hospitality. 20 years, a very unique body of the Council of Europe has been established in the field of justice, accommodating the representatives and professionals from 46 member states representing the ministries of justice, high judicial office councils, bar associations, prosecution services, judiciaries. They represent all the member states for promoting judicial legal reform in the European continent with aim to increase the efficiency and quality of justice for the sake of the more than 800 million Europeans. CEPEJ provides directions to the member states to improve their justice system and bring their judiciaries in accordance with the standards of the Council of Europe. Thanks to the commitments and efforts of all the members, experts and observers, the expertise in the area has won widespread respect not only among the European justice community, but also in the worldwide. CEPEJ has become an expert resource for developing and sharing solutions in the justice sector. As evidence of our reputation in more countries, even outside the Council of Europe area, as well as international organizations are indicating an interest in obtaining the observer status at CEPEJ with a view to further cooperation in the field of justice. During 20 years of intense activity, we focused and devoted ourselves to developing a wide range of tools and documents for use for court presidents and high justice officials, in particular in the field of evaluation of judicial system, quality of justice, digital justice, judicial time management, and enforcement of court decisions. I would like to focus very briefly on these achievements. As you know, the CEPEJ contributes significantly to collecting and analyzing judicial data, the complexity of which has increased over the years. The member of the evaluation working group and the national correspondents from each member state have played a pivotal role in ensuring the reliable qualitative and quantitative data. As a result, the CEPEJ biennial reports became the unique and comprehensive source of information about judicial systems in the world. The CEPEJ remains a strong advocate for both users and professionals of justice. In 20 years, the CEPEJ has entrusted working groups with mandate to develop measures and tools to support the process of justice. To develop the tools building the efficient and quality of justice system, which at the service of users. And some of the groups have already completed there. An example is the working group on the mediation, which contributed to the collecting mediation practices and developing a standards on mediation in Europe. The 4 working groups now are on a more permanent basis. Apart from the above-mentioned working group on the evaluation of judicial systems, the CEPEJ created in 2007 the Procedural working group in charge of collecting information on judicial timeframes and creating tools on improved judicial time management, management of courts, and prosecution. A year later, the working group on quality of justice was set up. The working group developed, as already was mentioned, the first European ethical charter, and it was the first time in Europe it was established the 5 main principles for the policymakers and professionals in the development of artificial intelligence in the national judiciary. In 2019, the CEPEJ created the Cyber Justice Working Group and adopted the action plan called Digitalization for Justice, providing for a few scope of intervention of the CEPEJ and its relevance many years ahead. The CEPEJ is a forum for exchange of practices and experiences, and therefore we set up a network of professionals that became, over the years, important partners. For example, the network of pilot constants. They served as a forum for information exchange, reflection, and trial of tools. The European Cyber Justice Network, launched in 2021, is a platform for interdisciplinary exchange of good practices and challenges in implementing information and artificial intelligence. The network of national correspondents plays an important role in the evaluation process. And the creation in 2005 of the Crystal Scales of Justice Prize also is one of the CEPEJ key events, as it enabled the promotion of innovative and effective practices concerning the functioning of justice, judicial procedures, or the organization of Korean jurisdictions. And also it's worth to mention that the European Day of Justice is a landmark event for the CEPEJ because it is an opportunity to users closer to the justice system. CEPEJ also assists member states to implement the measures and tools and the cooperation programs which rely on a strong connections with tools developed at intergovernmental level by the CEPEJ have evolved considerably over the years. The EU and non-EU partners, as well as the 1,000 member states, cooperated today with the CEPEJ in the framework of the bilateral and regional programs. For example, Albania, Azerbaijan, Croatia, Georgia, Kosovo, Latvia, Turkey, Malta, the Republic of Moldova, Slovakia, Spain, Morocco, Tunisia, Jordan, and Egypt. So at the moment, more than 12 projects are under implementation. And today, I introduce to you a very short overview of work of the CEPEJ done within the 20 years. And I do believe that we will continue our journey, this tireless to increase the quality and efficiency of justice in Europe based on the respect of human rights, democracy, and the rule of law. Mesdames et messieurs, chers invités, émirates and members de la CEPEJ, c'est pourquoi je saisis cette occasion pour remercier les membres de la secrétariat pour leur excellent travail et leur dévouement sans faille à leur fonction. En l'absence de professionnalisme, il aurait été impossible d'atteindre les objectifs dans le domaine du renforcement de l'efficacité et de la qualité de la justice en Europe par le secrétaire général, le comité de ministres et les présidents d'États membres. J'aimerais tout particulièrement rendre hommage à la secrétaire de la CEPEJ, Mme Muriel Deco, qui est la seule à travailler en permanence pour la CEPEJ depuis 20 ans. Son engagement envers le travail de la CEPEJ mérite reconnaissance et haute estime. In conclusion, I would like to wish all of us the interesting and fruitful discussions today on a very important topics with participation of a prominent experts, guests from different countries. I thank all of you for visiting us, for sharing this history. Thank you very much.
Thank you very much, Ramin, for your very interesting and always enjoyable speech, and your French intervention too. At this stage, I will invite Mr. Dolt, who's the head of the Department of the Human Rights. We will be disappearing from here. I don't know where, but somewhere. And in the meantime, I will be inviting Mr. Rosin, Ms. Mijailovic Moraru, Mr. Floriancic, and Mr. Veser Noguera, as well as, I think, the ambassador, Ambassador Schneider and Mr. O'Flaherty. I have no idea where you're going to sit, but they will, okay, we switch, okay. So, you will be doing away with my face for some time.
I don't know. I think you can go. Okay, this. Okay. Mesdames et messieurs les ministres et secrétaires d'État, mesdames et messieurs les représentants de la présidence et du comité des ministres du Conseil de l'Europe, monsieur le président, vice de la CEPEJ, merci encore une fois à vous-même et à vos collègues de votre hospitalité ici aujourd'hui. Mesdames et messieurs les membres de la CEPEJ, mesdames et messieurs les présidents de juridiction, les juges, mesdames et messieurs les représentants des comités participants du Conseil, le directeur de l'Agence des droits fondamentaux de l'Union européenne, Excellences, chers participants, merci à chacune et chacun de votre présence ici aujourd'hui. Permettez-moi simplement quelques mots ouvrir cette session consacrée au défi d'un système judiciaire numérisé. Et permettez-moi également de m'exprimer dans la langue officielle du Conseil de l'Europe, qui est le français, afin de respecter le statut de notre organisation. Depuis le début des années 2000, le Conseil de l'Europe soutient ses États membres dans leur pour introduire la numérisation au sein des systèmes judiciaires. Bien sûr, la numérisation est un processus technique appliqué au fonctionnement de la justice, qui n'est pas censé le changer en substance, mais le rendre plus efficace grâce à la technologie. C'est pourquoi, et conformément à son mandat, le Conseil de l'Europe a mené une réflexion approfondie sur les différents défis posés par l'introduction de la numérisation, notamment au regard des exigences du droit à un procès équitable posées par l'article 6 de la Convention européenne des droits de l'homme et les grandes valeurs de la démocratie et de l'état de droit, notamment la protection des données, la garantie d'un accès pour tous les usagers à la justice et la nécessité d'éviter la fracture digitale, le respect des droits de la défense, la place du juge dans la procédure et, il en a été question tout à l'heure, la préservation des symboles traditionnels attachés à la justice, pour ne citer que cela. La pandémie de Covid-19 a encore accéléré le processus de numérisation pour parer à la fermeture des tribunaux et aux restrictions de déplacement. Cette numérisation, dorénavant largement en cours et effective dans tous les membres, a-t-elle été effectuée en répondant aux défis annoncés? Ces défis ont-ils évolué en même temps que l'accélération de la digitalisation au sein des systèmes judiciaires? Les usagers et les professionnels de la justice ont-ils la même perception ou acceptation des progrès réalisés que les initiateurs des stratégies numériques? Ce sont autant de questions auxquelles les éminents intervenants de cette session, et qui sont assis autour de moi, session intitulée « Quels sont les défis d'un système judiciaire numérisé ?», seront invités à répondre. Monsieur Xavier Roncin, premier président de la Cour d'appel de Rennes en France, expert de la CEPEJ, introduira cette session en présentant justement sa vision des défis actuels de la numérisation de la justice. Différents éclairages vont ensuite nous être apportés par Madame Veronika Mihailov-Mouraru, secrétaire d'État, ministère de la Justice de la République de Moldova. Monsieur Damian Floriancic, président de la Cour suprême de Slovénie. Monsieur Antonio Vercher-Noguer, président du Conseil consultatif des procureurs européens du Conseil de l'Europe. Monsieur l'ambassadeur Thomas Schneider, président du Conseil de l'Europe l'intelligence artificielle. Et enfin, monsieur Michael O'Flaherty, directeur de l'Agence des droits fondamentaux de l'Union européenne. Sans plus attendre, je voudrais vous donner la parole, monsieur le Premier président Xavier Roncin, pour votre introduction, s'il vous plaît. Merci. Normalement, c'est allumé à distance. C'est bon.
Monsieur le ministre, Monsieur le Président de la CEPEJ, Monsieur le Vice-président, cher Francesco, Mesdames et Messieurs les membres de la CEPEJ et honorables invités, je voulais tout d'abord vous présenter mes excuses pour ma tenue un peu décontractée pour un événement aussi important, mais ma valise a décidé de voyager à travers le monde et avec mon costume. C'est évidemment un immense honneur d'intervenir devant vous à l'occasion de ce 20e anniversaire de la CEPEJ et de tenter de vous éclairer sur une problématique qui passionne depuis plusieurs années tous les juristes, les magistrats, les gouvernements, mais aussi les citoyens et les défenseurs de l'homme et des libertés, celui de l'intelligence artificielle. La question est la suivante. Face aux immenses progrès scientifiques, c'est un processus qui paraît inéluctable de digitalisation, de numérisation, de dématérialisation des écrits et des documents de nos sociétés et donc de nos procédures. Faut-il craindre ou faut-il espérer l'utilisation de ce que l'on appelle communément l'intelligence artificielle, mais qui n'est en réalité qu'une intelligence humaine augmentée? Loin du fantasme du robot qui remplacerait le juge, faut-il attendre en matière pénale une meilleure efficacité de traitement de l'information et donc des plaintes des victimes et une meilleure efficacité de la lutte contre la délinquance et la récidive? Faut-il espérer que les avocats et les juges, à la faveur de la constitution de gigantesques bases de données de jurisprudence qu'on appelle l'open data, cette jurisprudence prépare mieux quand ils sont avocats les arguments de leurs clients et quand ils sont juges, rédigent des jugements de meilleure qualité? Faut-il espérer aussi que les citoyens, mieux avertis de l'issue prévisible de leur procès, de celui qu'ils veulent engager ou choisissent grâce à l'intelligence artificielle, voies alternatives de conciliation et de médiation? Dernière question, ou avant-dernière, qu'est-ce que les parlements, les ministres de justice, les conseils de justice doivent désormais concentrer leurs efforts financiers non pas sur la construction de prisons, sur le recrutement ou d'éducateurs, mais plutôt sur l'utilisation de nouveaux outils algorithmiques pour améliorer l'efficacité de la justice ou pour évaluer l'échelle de risque d'un délinquant avant son jugement ou en fin de peine. Et cette question qui est centrale évidemment au sein du Conseil de l'Europe, est-ce que cette révolution numérique, ces choix technologiques mais aussi financiers éventuels de recourir à l'intelligence artificielle, est-ce qu'ils ne vont pas ruiner ou mettre à mal notre bien commun, la protection des droits de l'homme créée par la Convention de sauvegarde de 1950 et développée par la Cour de Strasbourg? Qu'il y a un risque qu'un jour on puisse notamment priver un citoyen de son droit d'accès à un juge ou au conseil d'un avocat? Est-ce qu'on peut courir le risque de priver le juge libre arbitre ou de toute liberté de décider, car il serait prisonnier d'une solution qu'un algorithme aurait déterminée afin, en théorie, de l'aider ou de le conseiller, mais en réalité pour limiter ses aléas de jugement? Autant de questions en tout cas passionnantes qui intéressent en premier lieu le Conseil de l'Europe, mais aussi l'Union européenne, et je me réjouis que vous en ayez fait le thème central de vos débats. Alors, quel éclairage essayer de vous apporter? Le premier éclairage, c'est que cette réflexion essentielle sur les conséquences de l'IA et devance très largement en Europe des utilisations concrètes de cette intelligence artificielle par des systèmes judiciaires. L'étude de la CEPEJ de 2018 du Conseil de l'Europe montrait que si plusieurs startups, si plusieurs legal tech s'intéressaient à l'IA, voire tentaient déjà d'analyser des produits, elles ne vendaient, après expertise en réalité, en matière civile, commerciale et sociale, que des bases de données judiciaires tronquées, imparfaites, et des produits eux-mêmes imparfaits qui tentaient de renouveler par des statistiques souvent elles-mêmes incomplètes ou fausses, ou en tout cas perfectibles, une approche qui était en marketing présentée comme très novatrice des moyennes d'indemnisation des différents préjudices patrimoniaux ou personnels. Quant à l'approche américaine de l'intelligence artificielle pénale à base de scores et d'évaluation de risque de récidive des délinquants, le fameux logiciel Compass, eh bien cette approche a fait l'objet de très sévères critiques universitaires qui ont dénoncé les préjugés raciaux et les biais de raisonnement des concepteurs de ce produit qui surestiment gravement ou sous-estiment le risque de récidive d'un délinquant jugé en fonction de la couleur de sa peau. Autrement dit, et finalement peu le disent dans les colloques, aucun système judiciaire n'a vraiment fait le choix de révolutionner totalement la manière de ces contentieux judiciaires au moyen de l'intelligence artificielle, parce que les produits n'existent pas, ou en tout cas pas encore, et que le marché, et que les opérateurs économiques, s'ils font rêve, maîtriser totalement le processus de création de ces algorithmes, ni trouver les équilibres financiers pour les vendre, pour persuader les utilisateurs, qu'ils soient juges, qu'ils soient avocats ou gouvernements, de leur utilité. Alors on le sait, la voiture plus intelligente, elle existe déjà, mais la justice augmentée reste encore à ce jour un rêve ou un cauchemar selon certains, mais en tout cas pas une réalité. Alors est-ce qu'il ne faut rien faire? Et c'est mon deuxième éclairage, c'est la nécessité de mettre en place une veille européenne. Ce n'est pas parce que ces produits encore ou qu'ils sont très imparfaits qu'ils ne vont pas un jour exister. Et je me réjouis des deux initiatives récentes et très importantes de la CEPEJ et du Conseil de l'Europe. La première, c'est de créer un source sous forme de tableau accessible sur le site de la CEPEJ afin de recenser en temps réel, et pas seulement tous les 5 ans, tous les outils d'intelligence artificielle et tous les outils de cyberjustice qui vont progressivement être implantés par les Européens, mais aussi par d'autres États dans le monde qui, un jour, nous inspireront. Deuxième initiative de la CEPEJ, c'est de créer un groupe d'experts appelé AIAB, dont la mission sera de conseiller la CEPEJ et ses différents groupes d'experts, mais surtout d'assurer une veille et d'expertiser les applications existantes d'intelligence artificielle dans les systèmes judiciaires. Pourquoi? Afin de vérifier qu'elles respectent bien la charte éthique de notre Conseil et ces 5 grands principes que je vous rappelle. Le principe de respect des droits fondamentaux de la Convention, et notamment l'accès aux juges. Le principe de non-discrimination dans la constitution des bases de données judiciaires, dans leur classification interne et dans le traitement des données sensibles. Le troisième principe de qualité et de sécurité, parce qu'il faut que les sources soient certifiées, il faut que les données soient intangibles et il faut qu'elles soient traitées par des équipes pluridisciplinaires. Le quatrième principe, transparence, neutralité, intégrité intellectuelle, afin de permettre à des observateurs extérieurs, à des tiers, de mener des procédures de certification ou de labellisation. Cinquième principe, je suis juge, celui de la maîtrise permanente par le juge utilisateur du produit, car ce juge doit toujours rester un acteur éclairé et maître de ses choix, protégé de toute approche prescriptive et qui doit pouvoir rester donc cette notion si classique du tribunal impartial et indépendant au sens de l'article 6 de la Convention européenne des droits de l'homme. Alors de même qu'en matière de médecine et de prévention des cancers, on dispose d'études qui vont comparer les mérites respectifs des diagnostics faits soit par un panel de médecins spécialistes du cancer, soit par des algorithmes de reconnaissance dits pour elle. Eh bien, c'est la même chose, il est indispensable de développer une expertise européenne des nouveaux produits d'intelligence artificielle qui seront utilisés en matière de justice. Troisième éclairage, toujours conserver la maîtrise de l'utilisation des nouveaux produits qui arriveront sur le marché. Pour prendre, il faut se rappeler que dans un outil comme le marteau, le danger ou le bénéfice, ce n'est pas le marteau qui peut aider le bricoleur, mais aussi le marteau qui peut aider à tuer une personne. L'outil, c'est le marteau, mais c'est la main qui tient ce marteau qui fera un bon ou un mauvais usage de ce marteau. Et il en est de même de l'intelligence artificielle, qu'il ne faut ni d'idolâtrer, ni de vouer aux enfers en matière de justice. On le sait, l'open data des décisions de justice va devenir dans peu de temps une réalité pays. Ce nouvel or noir, celui des données et de la conscience, va devoir être partagé. Mais en temps, cette condition essentielle, le respect des données personnelles et de la vie privée, la pseudonymisation avant toute publication grand public, dans le respect des législations ou européennes, le célèbre RGPD pour les pays membres de l'UE. L'ambition est donc grâce à ces nouveaux outils, d'exploiter ces données, de comparer des décisions rendues dans des cas semblables, de permettre aux avocats, de permettre aux juges d'en tirer des arguments pour améliorer la qualité de leurs respectifs, mais aussi de diminuer peut-être les saisines inutiles des tribunaux afin de trancher à moindre des contentieux répétitifs dans lesquels la solution juridique était. Pour cette raison, les juristes, les juges doivent s'intégrer aux équipes de conception de ces nouveaux produits et ne pas les subir afin de tenir toujours à l'avenir le fameux manche du marteau. De même, il faudra éviter l'effet boîte noire qui, dans un processus, par exemple, de règlement en ligne, des petits litiges, de la consommation, il faut éviter que cela confie aveuglément ou à des raisonnements cachés, occultes, la solution transactionnelle qui va être proposée. Il est donc nécessaire qu'à un niveau national et de préférence européen, on puisse imaginer des processus d'accréditation, de labellisation par les pouvoirs publics de ces nouveaux produits d'intelligence artificielle afin que ceux qui vont les acheter, ceux qui vont les en connaissent parfaitement les avantages et les limites et une fois de plus en conservent une totale maîtrise. Et c'est ce que la Commission européenne, dans son nouveau projet de règlement, a proposé en avril 2021, elle qui classifie et qui qualifie à juste titre l'utilisation de l'intelligence artificielle dans les activités judiciaires comme une activité à haut risque qui impose donc une grande vigilance et un strict respect des droits fondamentaux, dont celui que je citais tout à l'heure du droit permanent d'accéder à un juge. Pour conclure, ce qui fait l'humanité de la justice, c'est la singularité nécessaire de chaque dossier, qu'il soit civil, qu'il soit pénal, dès lors par un juge. Ce qui fait l'humanité de la justice, c'est la singularité nécessaire de chaque décision de justice. Ce qui fait l'humanité de la justice, c'est la singularité de l'émotion ou de l'adhésion à un raisonnement intellectuel provoqué par un avocat qui plaide devant un juge. Et il nous faut donc tous collectivement préserver cette singularité, y compris dans les contentieux de masse. L'intelligence dite artificielle, le robot ne remplaceront jamais le juge dans nos systèmes démocratiques et ne doivent pas le remplacer, mais nous sommes nombreux à espérer qu'un jour dans l'avenir, l'intelligence artificielle augmentée aidera ce juge à mieux juger et à plus vite juger pour le plus grand bénéfice des citoyens de nos 46 pays. Et je crois pouvoir affirmer que grâce au Conseil de l'Europe et à la CEPEJ, nous sommes tous mieux et même armés intellectuellement à répondre dans l'avenir à ce défi démocratique de la révolution numérique, de la digitalisation progressive de nos sociétés. Je vous remercie de votre attention.
Merci beaucoup. Merci, Monsieur le Premier Président, d'avoir brossé ce tableau introductif où nous avez présenté les défis technologiques et financiers, mais aussi, et je vous en remercie, insister sur la nécessité de préserver la protection des droits de l'homme. Vous avez insisté sur le fait que les réflexions, les discussions actuelles précèdent en réalité largement l'usage de l'intelligence artificielle dans la justice. Vous avez dit la justice augmentée reste un rêve ou un cauchemar. Vous avez aussi souligné la nécessité absolue de disposer d'une expertise. Donc, cela montre bien l'intérêt de vos travaux qui tombent à point nommé. Vous avez aussi, et je retiendrai cette expression, mis en lumière l'importance de tenir le manche du marteau et de conserver l'humanité de la justice. Merci beaucoup de ce tableau introductif. Je voudrais inviter au podium Madame la secrétaire d'État Véronika Mihailov-Morao.
Excellencies, dear participants, I am delighted to greet you on behalf of the Ministry of Justice of the Republic of Moldova today. We are very grateful to you for organizing this plenary meeting where we could discuss this and also to share with you about some in the justice sector in Moldova. We all know how it is an effective and the justice sector for the economy and security of a state. That's why last year our parliament adopted the strategy on ensuring the and integrity of the justice sector for next years. And this strategy sets out 3 directions for action. First, the independent accountability and integrity of key actors in the justice sector, access to justice and quality of justice, and 3, and modern administration of justice. So, in line with the government goals, we have already launched a number of key reforms. And a very big attention is to the process of digitalization of justice, which also requires cardinal change of mentality and legal culture. Digitization of justice aims to facilitate access to justice, improve overall efficiency, and ensure the resilience of justice systems in times of crisis. I would like to mention about some development in this segment in the Republic of Moldova. About implementation of the new electronic statistical reporting module from 2020 in the Republic of Moldova. Thus, the Court Administration Agency as Subdivision of Justice has the tool to extract data automatically through the integrated file management program, making it possible to extract data according to the 17 performance indicators recommended by CEPEJ. Thus, the judicial system in Moldova makes an important leap in the direction of the digitalization of judicial activity, and the recommendation of CEPEJ action focused on improving of statistical data, the application of efficiency indicators. The judicial IT solution, a computer application developed and made available to litigants for the purpose and administration of the judicial file in electronic format, is an interconnected rated case management program used by national courts for automated and evidence procedural action. And the judicial e-file application is a component part of a state judicial information system. And in order to streamline the judicial information system and to exclude the intervention of the human factor from the administrative process, and we had a lot of problem in this sector, it is planned that the e-judicial file application will be implemented, of course, by the end of 2023. At the beginning of 2021, so far, the Court Administration Agency, our member and observer of the USTAT project working group implemented by the European Commission for the Efficiency of Justice in partnership with the authorities of the Republic of Moldova towards the implementation of a national platform similar to the public instrument for exploring the CEPEJ database. Thus, actions are taken in development of the online tool for consultation and analysis of data in the judicial system of the Republic of Moldova and implementation at the national level of the instrument CEPEJ. I would like to mention that pushing by the pandemic crisis, we were obliged to the teleconferencing used in the process. So during 21 of the hearing, around 6 persons were conducted by the video conference, and this number is increasing. The use of the video conferencing service is also part of the new justice reform project, and we want to continue to expand the type of the cases after a lot of amendment in the legislative framework. And in order to facilitate access to justice, especially for vulnerable groups, qualified legal aid guaranteed by the state can be submitted online. In addition to the information system within the court, the authorities' efforts are also focused on the development of information system aimed at managing cases of the criminal prosecution and enforcement of judgments, but also digitizing the activity of legal professionals, such as notaries, lawyers, judicial experts, and insolvency administrators. Of course, there are a lot of difficulties which we are trying to solve it step by step. For example, low level of computer use, internet access, low legal culture, lack of knowledge of the public judicial process. We have to be honest, even for us, a legal profession, and for the next lawyer for 15 years is still a big challenge of the digitization process. So we need to adapt it step by step. That's why we are also focused on how to integrate this process of digitization to be adapted to the people's needs. Finally, we believe that only by opening up, accepting the new, by quickly communication between the units of the judiciary, by standardizing procedures, can the efficient administration of the justice sector be increased, and of course, certain risks and vulnerabilities, but also increase the transparency and trust of citizens in the public services. Finally, I would like to express my congratulations for today's anniversary, to thank to CEPEJ for all the support of Moldova, and I wish also for a good collaboration in the future in the digitalized justice. Malheureusement, je n'ai pas réussi de préparer mon discours aussi dans la langue française, mais je veux de souhaiter vous bon anniversaire et vous remercie pour cette occasion de participer ici avec vous. Thank you for your attention.
Merci beaucoup, Madame la Secrétaire d'État, de nous avoir présenté l'expérience concrète moldave, en particulier la stratégie digitale pour la justice, mais d'avoir insisté sur l'importance d'avoir une justice qui réponde aux besoins des usagers, c'est important. Je voudrais à présent inviter au podium Monsieur le Président de la Cour suprême de Slovénie, M. Florian Šić. Vous avez la parole.
Ladies and gentlemen, it is a great pleasure for me to address this forum today here in the celebration of the 20th anniversary of the CEPEJ. Thank you for your invitation. First of all, let me congratulate the people working for and with the CEPEJ. Your work is of great importance to the judiciaries of Council of Europe member states and is of great and policymakers all over Europe. As you know, Slovenia has been very involved in the work of the Council of Europe and the CEPEJ. My esteemed colleagues at the Supreme Court have been very active in fields. The Supreme Court of Slovenia is the proud winner of the Crystal Scales of Justice Prize from 2019 with the project improving the quality of justice, where of our activities were in the central focus. And last year we also hosted the Crystals of Justice event. It is through the work of my colleagues as President of the Supreme Court, follow and understand your work better. Of course, our judicial systems differ in many ways, from our legal history to our organization, written and unwritten rules and customs. Nevertheless, it is our common goal to deliver our citizens a just and fair trial within a reasonable time in front of an independent and impartial judge. We have different ways and paths to achieve these goals, and that is so important to have an international forum where different ideas, concepts, and experiences can be shared and compared. I am grateful to the CEPEJ for the work it does. I was asked to share with you some thoughts on the digitalization of justice and my views on where our judiciaries are heading. Of course, we are all aware of the fact that the COVID-19 pandemic and all its consequences gave an unprecedented boost in advances and forced us all to change our daily work. From Zoom meetings to hearing through video conference, we all got used to that pretty fast. With the pandemic now hopefully behind us, we can see there are big differences among us. Some have embraced these innovations, would never go back. Others cannot wait to switch their computers and cameras off and go back offline. This is not something new. Looking back in time, logical innovations, we can see that in general, they are first met with skepticism and suspicion, but soon they become our daily companions and assistants. It has been with different innovations, and it will remain so. The most difficult part in change management is changing people, their habits, and their perceptions. Once this is achieved, the technological step itself is not that difficult. My main message would therefore be: listen to the people, not only the people who come to courts as users, parties in proceedings, but more importantly, to the people working within your judicial system, judges and court staff. Without their understanding and support, any minor change can become an endeavor. On the contrary, having the support and understanding of users of technologies represents the essential condition for a successful technological leap. Professor Richard Susskind, the world's most cited on the future of legal services, states that we have increasingly capable machines and that the pace of technological change is accelerating. In my view, it is important to distinguish two types of technological advances in our work. On one hand, we have automatization. With the help of technological advances, the business process is streamlined, reorganized, and made more efficient. However, the of technological advances only builds on the existing parameters and uses technology to improve the workflow. On the other hand, we have disruptive technologies that completely change the way things are done and reset the state of play in certain field. While it is somehow expected to be able to adapt digitalization of already existing processes, it is impossible to prepare for the innovations that might and will occur. The technologies that will affect our work in the future might not even today. It is because of that we always have to have the bigger picture in mind. What is the task of a judge of a court? In my opinion, it is essential that we understand the core function of justice trained in Article 6 of the European Convention on Human Rights and Fundamental Freedoms. There is stated, everyone is entitled to a fair and public hearing with reasonable time by an independent and impartial tribunal established by law. The way this is a secondary question. It is up to us to organize our work in a most manner, taking advantage of all technological advances, and these basis principles always in mind. What we have to do is take what is best in technology, rethink how work is done, and based on the construct new business processes that allow the differentiation of access to justice. For hundreds of years, judiciaries have been a complex system that takes too long and is too costly. Digitalization and technological advances offer us the ability to overcome these assumptions, to bring justice closer to people, and enable true access to justice. We just have to be very cautious. On one hand, we have to understand that artificial intelligence and all the flawless technological wonders can quickly lead to wrong decisions based on wrong incoming data. And I would like that in May, presidents of Supreme Courts of European Union, we had a colloquy in Stockholm dealing with exactly these questions about artificial intelligence, about digitalization, and we all agreed that there are negative parts of these questions, and we have to be especially be aware about the negative aspects of these questions. Of course, machines learn and improve, but human control is needed. On the other hand, it is important to train justice professionals to use the technology and take advantage of the improvements it offers. Some parts of the procedure will be done online, other parts in person. Some procedures will be digitalized, others maybe just partly. There is nothing wrong with that. We have to understand that technology is that helps us in our important task to deliver justice. It is therefore very important that developers and IT specialists hand in hand with judges and court staff to deliver solutions that fit the needs of people working in the judiciary. Last but not least, we must be very attentive not to digital divide even larger. Yes, new generations are digital natives, working and communicating on smartphones and laptops daily. However, we also have groups of citizens that are not familiar with technology. because it frightens them, or simply they have never had access to it. We must not forget them. It is therefore our duty to offer multiple options, from completely informatized to old school in-person communication. We should find our ways how to address people and other categories of non-digital populations. No one should be left behind. Digitalization of justice should therefore always be accessorial to the core function of judicial decision-making. Technology can help us construct wonderful data warehouses and virtual case law libraries. It can help with writing, legal analysis, case management, communication with parties and other legal professionals, etc. At the same time, it can lead to exclusion, biased decision, and injustice. It is our common duty to make sure this does not happen. In this context, I'd like to stress the importance of addressing ethical questions in the use of artificial intelligence and the pioneer role of the CEPEJ in this regard. To conclude, I would like to stress that in the end, it all comes down to people. If judges and court staff understand the importance of core judicial values as independence, impartiality, transparency, accountability, and fairness, then technical advances will be seen as an opportunity, not as a threat. Invest in people, provide them sufficient training and support, give them the opportunity to do their own best, and they will repay you. At the age of 20, is experienced enough to know which paths to take, and I'm still young enough to embark on new, unexplored adventures. I call once again on your achievements and wish the CEPEJ all the best in the future. Thank you.
Merci beaucoup, Monsieur Benny, pour ce regard prospectif sur les développements de la justice. En vous écoutant, je me disais que l'artiste qui a réalisé le tableau offert à la CEPEJ pour ses 20 ans a vraiment bien fait. Finalement, c'est ça ce que vous nous avez décrit, l'importance de ce dialogue entre prudence et justice, les deux genres qu'on voit sur ce. Merci beaucoup de vos propos. Je voudrais à présent inviter au podium Monsieur le Président du Conseil consultatif des procureurs européens, Vercher Noguera. Monsieur le Président, vous avez la parole.
Well, good morning to everybody. It is an honor and a pleasure to be invited to the ceremony of 20 years of the European Commission for Efficiency of Justice, CEPEJ. And I would like to extend my sincere greetings on behalf of the Consultative Council of European Prosecutors to all participants. I would like in particular CEPEJ for an excellent organization of this important event. Well, CEPEJ goes with efficiency, so up to a certain extent, it's logical. But still, it's a great job. I would like to express my congratulations as well to the Maltese authorities. I have to refer to a general point, which has not been the CEPEJ, but I have to say it for ethical security. Everything is perfect, even the climatology, right? In fact, I was born in a small town in the south of Valencia, called Tavernes de la Digna, which has a very strong Maltese community. Apparently, hundreds of people from Malta who came to my town 300 years ago, and in surnames such as Mifsud, Fennec, Bonacci, Manclus
are extremely popular and common there. I have very good, important number of pursuits. It's really surprising every time I come here. I see so many pursuits in the street and so many names which related to my town, the place where I was born. So it is a real pleasure, and well, I had to say it basically because it's something that I feel in my heart. And every time I go to my place and I get in the Maltese community in my place, I simply, because the third time I came here, I take the opportunity to express it. Sorry. Well, everything has been perfect, as I was saying. In any case, I will ask Mr. Xavier to tell me exactly what did he buy his intelligent suitcase, which decided by itself to travel around, because certainly I will buy a suitcase there as well in the future. It's much more relaxed to dress in the way you are dressing. So please don't forget that. I will inquire afterward. Now going to CEPEJ and the CCPE, I'm very pleased with this opportunity to make a presentation, and I would like to use it to say briefly a couple of words about the Consultative Council of European Prosecutors' significant role in the overall structure of Europe's bodies. The CCP is in fact a unique body of its kind, comprised of serving prosecutors from each of the member states in their individual capacity. In this way, the CCP provides a voice and perspective of serving prosecutors throughout Europe. It focuses on the context and aims to help ensure prosecutors can work in an independent, impartial, and effective way when fulfilling their important responsibilities with the national legal system. This is what I'm saying. It looks very formal, but the fact is, in practice, it works that way. We had problems, and we had different comments and reports brought by different countries when they had problems relating the prosecution system. The fact is that in practice, everything has been very positive, and we managed in several occasions to solve problems which couldn't be solved. So, in fact, what I'm going to say again, as I said at the beginning when I was in all aspects, I say it really from my very heart, from the very deep of my heart. I agree that prosecutors play a powerful and influential role within society, and their voices is important, as it is important to uphold through the action of law, fairness, impartiality, and safeguards the liberties and freedoms of fellow citizens. Prosecutors and prosecution service, tenacious in their pursuit of justice, protective in their impartiality, actively cooperating internationally to combat crime, and especially of political control and political direction will be always about freedom and liberty. That's extremely important for us in something which is basically being repeated in our different opinions. The CCP is on some occasions as the prosecutorial arm of the Committee of Ministers of the Council of Europe. I think we are very proud of that. This covers all principles and practices which are assembled, analyzed, and transformed into soft law guidance, which the Committee of Ministers transmits to all member states, enforcing the status of prosecutors and their independence, impartiality, and effective work. And we feel, as I mentioned, extremely proud of that. The establishment in 2004, the CCP has adopted 60 opinions that is able to show, obviously, which is the of work we are enduring in the last years. Normally, those opinions are dealing with problems in practice you have to face quite often. It covers the most essential aspects of the prosecutorial profession and support not only of prosecutors but also of policymakers and other legal professionals. CEPEJ standards help it in a conducive legal, institutional, and procedural framework for prosecutors and consequently enable them to effectively work on cases and disputes at national level, in line with the Convention of Human Rights, as it should be, and the case law of the European Court of Human Rights should be as well. In this context, CCP also touched upon the development of new technologies and progressive improvement of video conferencing systems in the judicial and prosecutorial systems across the Council of Europe's members. I admit that digitalized justice systems might create new opportunities but also face some challenges. The CCP underlined in particular the development of new technologies create new possibilities for ensuring the hearing of witnesses, experts, and defendants without the need to compel them to travel to different venues with member states where the investigation or the trial are being conducted. Obviously, by some examples in Europe, this could be of greater interest in cases of emergency, avoiding or reducing limitations on the functioning of the prosecution service and courts, while ensuring safety and facilitating a hearing that allows parties to fully participate. The objective should be to make the remote proceedings and hearings closest to the usual practices in the prosecution service and the court. The European Court of Human Rights established in its case physical absence does not necessarily constitute a violation of the right of a fair trial. The European rights pointed to several international instruments that provide for participation in the trial, using conferencing as a way of respecting Article 6 of the European Convention of Human Rights. And it has been adopted several judgments as regards the use of video conferencing. The CCP emphasized in this regard that when video conferencing in court, due attention should be paid to the interest of all parties, particularly the preservation of the rights of the defense. Regarding the webcasting of court sessions in normal conditions is being used to reach a wider audience and to encourage a broader interest in the aspects of public life touched upon by courts. When it comes to an emergency situation, webcasting is even more justified for the civil engagement, but in order to expressly demonstrate that justice is being performed openly and in public. In accordance with the prosecution system in each member state's guidelines by the prosecution service at the central level, highlighting cooperation mechanism and including the use of new technologies both within and outside the prosecution emergency circumstances. In guidelines at central level, if guidelines at central level not possible due to the organizational setup of prosecution service, should at least strive to be coherent across different prosecutorial systems. Uniformity of application in the law regulation should be expected from prosecutors and prosecution service throughout the states concerned. Specific cooperation and coordination mechanisms or procedures, including the use of new technologies, might be established during emergency situation with other institutions, such as government agencies, investigation and control bodies, courts, health institutions, media, professional association of prosecutors and other civil society organizations. Cooperative and coordinative arrangements might include personnel and other agencies. In normal situations are not necessarily in contact with the prosecution service. The conduct of investigations or the supervision of those carried out by police and other investigation authorities must be implemented with a particular vigilance for monitoring the rights and freedoms in the context of an emergency situation. An extended power of the prosecution is not envisaged here, but rather using the existing powers most effectively in such situations. In this context, victims and witnesses and other vulnerable groups should be effectively assisted and or protected, and defendants should be respected throughout the criminal procedure. The prosecution service and prosecutors should particularly monitor whether emergency measures interfere with fundamental rights and freedoms to a greater extent that is strictly. There are some parts of the CCP standards, in particular from the CCP opinion number 15, issued in 2000 on the role of prosecutors in emergency situations, in particular when facing a pandemic, which had the use of new technologies and progressive improvement of video conferencing in the judicial and prosecutorial systems across the Council of Europe member states. Two last remarks I would like to make. One is the fact that, as it has been quite clearly indicated by Monsieur Nouli, sorry for those two names, Mr. Dan Florjanic, President of the Supreme Court of Slovenia. It was also mentioned by Mr. Ronsin at a certain stage. The fact is that sometimes we face the use of new technologies as something absolutely positive, which is logical to a certain extent, but we don't have to forget the fact that very often also for organizations and institutions of private character, the perspective regarding that sort of things is basically the perspective of cost-benefit, benefit approach. It's much easier that use of new technologies for the approach than human rights, than the defense of human rights itself. I mean, I'm not criticizing anything. I know that Article 1 of the Protocol number 1 of the European Convention of Human Rights makes quite clear that property is a human right. Actually, the entrepreneurial perspective attached to property is away in human rights. That's absolutely important. But we do not have to forget levels, especially real enterprises and economical power. When those aspects are taken into consideration, the benefits are very often there. Our approach is completely different. Our approach is that the only thing that has to prevail in that sort of situations, even in cases of emergency, the defense of human rights. The last remark is something that, well, has been mentioned by Mrs. Buckley. I really appreciate her words. I was here about the ideas and the initiatives to be taken by Ireland in the presidency of the Council of Europe is fantastic. Well, she mentioned as well about the recommendation on the protection of environment. It has with new technologies and everything that is being discussed here today, because in environment, new technology is absolutely essential. It's something which is absolutely there. I mean, technology is always there. So those are common points between environment and new technologies apply to cases of emergency and sort of topics we're discussing today. Well, the fact is that in the Council of European Presidency working on an opinion on the protection of the environment, and it's not casual, that it's not a coincidence that we did it that practically after the COVID. So we resorted to that, considered as extremely important. So my warmest congratulations for that initiative. The recommendation is going to be great use for us when eventually we discuss in the plenary in November the content of the opinion. So thank you very much indeed, and thank you very much indeed for your attention. There are so much cases and aspects and information that it's difficult to retain everything. So logically, you have to make an effort. Thank you very much for your effort.
De nous avoir présenté la voix et la perspective des pairs européens sur ces questions. Vous avez notamment insisté sur les nouvelles possibilités offertes par le numérique dans les enquêtes, notamment pour réagir. Vous avez aussi, à juste titre, souligné l'importance des garanties de préservation des droits fondamentaux. Merci pour ça. Je voudrais à présent, nous parler du digital, du numérique, je voudrais à présent présenter le prochain intervenant qui nous rejoindra justement online, un grand spécialiste de société de l'information et du digital. Nous avons beaucoup de chance, il est aussi le président du comité du Conseil de l'Europe sur l'intelligence artificielle, monsieur l'ambassadeur Thomas Schneider, que nous devrions voir apparaître à l'écran sous peu. Voilà.
Bonjour
Parfait.
Frédéric, vous m'entendez?
Nous vous entendons. Excellence, cher Thomas, vous avez la parole.
Thank you, Excellencies, ladies and gentlemen. Great pleasure for me to participate in your meeting, celebrate with you the work of the CEPEJ in the past 20 years. I would love to be with you in a beautiful Malta, with or without intelligent suitcase, but unfortunately, due to other commitments, I'm not able to be with you online. As the current chair of the Committee of Artificial Intelligence and a former member of the Ad Hoc Committee on Artificial Intelligence for Switzerland, I can assure you that the work of the CEPEJ on AI in principles of the ethical charter on the use of AI in judicial systems is truly pioneering. Your work was very useful for the KHI, not least in providing inspiration on how to address the issues of deployment of AI system in human rights and rule of law, the administration of justice. I am not an expert in the administration of justice, and I hope therefore you will forgive I'm not trying to see the challenges of a digitalized justice system, but that you allow say a few words about KHI's work and its relevant page. The KHI's mission on 31st December last year, having adopted and submitted to the Committee of Ministers both a feasibility study on a legal framework on AI design, development and application based on and paper detailing the possibilities of a legal framework on artificial intelligence based on Council of Europe standards on human rights, democracy and the rule of law. KHI offered a multi-stakeholder at Malta for brainstorming on the question of if and how relate the design, development and application of AI systems to ensure compatibility with relevant human rights and rule of law standards. With the KHI, the committee, these are very easily confused. Committee of Ministers is now provided for the next steps. This new committee has been targeting an appropriate legal instrument on the design and application of AI systems based on the Council of Europe standards and conducive to innovation by 2023. So this leaves us effectively 12 months to conduct the negotiations, which is a very ambitious schedule. In addition, the CAR has been tasked with coordinating, or as I personally would rather say, facilitating its work on AI with other committees, including by providing advice to them where appropriate. The legal instrument, which will be based on work done by the KHI and the instructions received from the Committee of Ministers. Underline that the instrument should be of transversal character and focus on general principles. In short, the transversal instrument will not address specific AI issues in much detail, but instead provide the general for the development, design, and application of AI systems. However, where there may be a need to regulate more closely, this should be sector by sector across the Council of Europe mandate by the relevant steering committees, which have both do so and are responsible for the policy making in their areas. Can and should indeed happen in tandem with the work of KHI if close coordination on key points, definitions used is ensured. In the case of the CEPEJ, I'd like to highlight that the instrument prepared by KHI will also some basic concepts which are important for the rule of law. I will therefore call on your committee to provide the KHI with your precious expertise and to actively assist us in formulating the applicable guiding principles on how to best regulate in decision-making in the public sector, of course, as regards the administration of justice. I personally have been actively participating more than 50 of another steering committee of the steering committee on media and society and many of its expert groups. In the CDMSI, we have been looking into the impact of the internet and digital on human rights, in particular the right to freedom of expression, the right to freedom of association, and so the right to private life. In the past few years, we have put an increasing focus of algorithmic systems in the media, in the public sphere, and in democratic processes. To an instrument that we have developed under my chair 3 years ago is a recommendation on the human rights impact systems, which was adopted by the Committee of Ministers in early 2020. Let me end by mentioning some very basic regarding the increasing use of artificial intelligence, both in private sectors. Firstly, AI is for good, a servant of humanity, and should not replace the rule of law algorithm. This, in fact, does not rely on the technology, but on in which it is used or abused human beings. Secondly, technology is neither inherently good or bad. It offers great promises ranging from science and medicine to business and also public administration. At the same time, overruling the infallibility of technology combined with a lack of understanding of AI functions may lead to serious breaches of the rule of law. Unchecked surveillance, together with facial recognition and even worse, emotional recognition, making AI and combined technologies may not undermine basic human rights, but the fabric of democracy. Hence, there is every reason to now establish a proper legal framework, ensuring that existing and human and other legal rights continue to be seriously applied in an AI context. This be left to self-regulation by the industry. At the same time, my experience from the MSI has taught me that it is crucial that we are involving not just government, but all stakeholders, civil society, history, and the technical community into our work. This helps us to ensure that we do not build instruments that look good on paper, but instruments that can be implemented by all stakeholders, of course, in their respective and different roles. Multi-stakeholder dialogue and even more important in the field of AI, where governments often struggle with keeping pace with developments driven by science and industry, what the technical and economic circumstances are that these technologies are being developed in. It is therefore, in my view, indispensable that we enhance dialogue cooperation also across the silos within the Council of Europe in order to be at the same time able to understand the full picture of what is going on and to be able to develop appropriate specific sectors of our expertise. The CEPEJ has therefore decided to seize the fact that I am currently one of its bureau members, so that I should help them to facilitate the exchange of information and expertise between it and in order to enable us to best fulfill our mandates. It is not only important that all relevant standard settings have channels for such exchange of information and expertise with the CAI, but actually also all other others' work should be connected to each other as we face more and more of the dependencies. Finally, AI is a global technology. Challenges it raises cannot possibly be addressed efficiently at the national or regional levels. The world needs a globally binding instrument on how to develop these AI systems in accordance with the rule of law. Despite it being an organization, the Council of Europe has a history of providing such legal solutions reach way beyond Europe. Of course, the most probably the Budapest Convention on Cybercrime that you're well. And it is my hope that we can repeat this also on our instrument on AI. I am for this reason also pleased to note that the interest of the work of the CAI comes from states from all over, way beyond Europe. This is a unique opportunity to find common ground while involving civil society, academia, the technical community, and the in the process of establishing certain basic principles to govern AI systems and ensuring that the benefits of this groundbreaking technology can be enjoyed by all persons across the world. I thank you very much I wish you a successful meeting over there in Malta. Thank you.
D'avoir rejoint depuis la Suisse et d'avoir placé les travaux de la CEPEJ sur de la justice en perspective avec les travaux plus généraux du Conseil de l'Europe sur ces questions, et en particulier sur celle de l'intelligence. Nous avons aussi entendu votre appel concernant l'importance que la CEPEJ contribue et nourrisse les travaux du comité sur l'intelligence artificielle. Et aussi ce conseil de développer qui ne soient pas seulement belles sur le papier, mais qui soient aussi utiles et efficaces en pratique. Je voudrais à présent inviter au podium Monsieur qui est le directeur de l'Agence des droits de l'Union européenne. Monsieur le directeur, nous sommes très honorés de votre présence avec nous ce matin et qui est la proximité de notre coopération. Merci. Monsieur le directeur.
Merci Frédéric. Bonjour, chers collègues, Excellence. I'm very grateful to be here. I appreciate the invitation, the cooperation with you, which we've had now over many years. We congratulate you on the 20th anniversary. We express appreciation. You're the first globally to address the issues of the digitalization of justice, and tools you've developed, standards on ethics, on good practice, are being used worldwide, and we appreciate the leadership. But as I speak, I'm also conscious that I'm between you and coffee, and in coping with that reality reminds me to be pretty brief. There's been speaking appropriately of the COVID times and how it accelerated the digitalization of justice in many different ways. We at the Fundamental Rights Agency, at least with regard to the E7 member states, followed the story very closely and periodically published analysis of the interplay of COVID and fundamental rights. And we would agree with much of what was said this morning about the positive dimension of digitalization of justice in that period, the extent to which it allowed basis for access to justice, speeded up proceedings, it cut costs, it even enhanced protection for vulnerable victims and witnesses. At the same time, we observed, again across the EU member states, a number of problems. One had to do with access to the necessary skills, which then triggered issues of equality of arms, one side with a better use of the technology than others. There were issues of the missing of deadlines all over the place, all the time, experienced practitioners. There was concern to ensure it be delivered in public. This, of course, triggered some very positive good practice, such as allowing journalists to have privileged online access to proceedings, including in the criminal context. There were concerns of the rights of defendants who didn't have physical access to a lawyer. And then, worryingly, in a lot of EU member states, there was a lack of guidance to use the technology, or at least in some places, plenty of guidance, but there weren't joined nationals in place. And so there's a lot we can learn from the COVID time going forward, including in the context of which bits of the technology we're going to maintain as standard practice. And of course, then, looking to what we'll do in the future, we have to locate the whole discussion in the frame, as we've heard repeatedly this morning, of artificial intelligence. And again, as we've heard from many speakers this morning, the issues of the application of artificial intelligence in the context of justice is potentially vast and is subject right now to some quite remarkable experimentation. Just to take the criminal context, we see ideas, initiatives, experimentation in the context of predictive policing, prosecution, sentencing, and probation. And it's not for me to get into the specifics of each of these this morning. Rather, I'm conscious that it is states, courts, to make difficult decisions as to which of these applications is or is not appropriate in the context of respect for human rights. The role of my agency, on the other hand, is to deliver the research to help you, governments, to take such decisions. We've been invested in the for a number of years now. We've developed a lot of insight to help us all go forward. We have, for instance, generated an understanding of government in which we have to make our choices. Let me just give you 3 elements of the environment that we have detected. The first is, and this is verifiable, the primary driver of AI in any context applied is speed and efficiency, not quality. There's nothing wrong with that, but nevertheless, there's a warning light that as we apply the AI solutions to speed things up, to make things more efficient, we have to be extremely vigilant that we do not do at the expense of, let me call it, human rights quality. The second element we have to keep in mind in terms of the topography for AI is the extent to which, keep remembering, AI is driven by data. We need to remember the extent to which our data is flawed. It's empirically verifiable that it's an astounding amount of the primary data that feeds the algorithm to the outcome is wrong. We've researched this in numerous contexts. Take, for example, a judicial one, but take for the large-scale IT systems at the European borders. Something like 30 to 40% of the data can be shown to be erroneous, with enormous human consequences. And then the third of these topographical dimensions, the last one I'll mention, is that the technology does not stay still. It is ever evolving. And this means our decisions, our analysis must never stop evolving. We've been working on facial recognition technology for the last 7 or 8 years. And every time we think we're finished with clear guidance from member states, we have to start again because the technology is moving on. That's why, for instance, right now, we're on facial recognition technology context of the role played by feedback loops, something nobody had even heard of back when we started again 7 or 8 years ago. And finally, in terms of the topography, I would want to echo what Ambassador Schneider said just now, which is with the need for strong regulation. I want to associate myself with practically everything that Ambassador Schneider said to us just a moment ago. And I applaud the work of the Council of Europe, the work of CAHI and CAI, in which they are leading us. I also acknowledge that the EU itself is making major advances in terms of towards regulation. We already have the data protection regulation. We now have the AI regulation, which is currently in negotiation. But one important dimension of the current draft of the AI regulation is that it identifies the application of AI for the administration of justice as being high risk. We at the Fundamental Rights Agency think this is a very wise and correct decision. A recognition that application of the technology in the justice sector, while it can bring enormous good, must be watched with great vigilance. And to conclude, what does watching with great vigilance mean? I will very briefly propose to you 6 elements that we derive from law, from ethics, and from empirical research, how we watch the application of high-risk technologies, including in the justice sector. First of the 6 is that we must never let go of human. There is no room in a high-risk application for autonomous machine outcomes. There must always be a person, as indeed we heard from Judge Ronsin. Second, every application we apply in a high-risk sector must be subject to an ex-ante human rights compliance check. We need to know in advance what needs to be watched. Third of my 6, we need the application of strong regulatory oversight systems for the application of such AI uses. I say that's rather obvious, but from the point of view of human rights oversight, it's not. We see repeatedly how oversight systems engage only part of the human rights context. Privacy, for example. Privacy is never overlooked, but many other areas of human rights, such as protection from discrimination, can be neglected. The fourth of my 6 has to do with what happens when things go wrong. And again, typically, this can be overlooked. It is the issue of the right to a remedy, an individualized remedy for a person who is wronged by a misapplication of the technology. And again, it's important to build such rights into whatever regulatory instruments we develop. And fifth, and this is so central to everything, it should really be more like an overarching principle than the fifth of a list of 6, and that is honoring the principle of transparency. We can achieve nothing if we do transparency, and here I'm particularly referring to the transparency of the AI technologies. We need to know what's in the algorithms. We need to know training data was applied. We need to have all the information so that we can make our necessary assessments. Sixth and finally of these principles, again, it's rather obvious, but it's still very challenging, and that is that as we roll out the digital justice, we have to invest in the related. Again, it's rather obvious. It is typically underinvested. And there's a dimension to it which we have not yet really got a smart solution for, which is that it's not just about training lawyers, court personnel, it's about training litigants, including lay litigants. And this, I think, would be fascinating to going forward, how you inform the general public about the application of AI in the digital context so that you can ensure that justice is done for them. I leave it there. I want to thank you again for your attention, to assure you that the Fundamental Rights Agency, European Union, is at your service. Continue to support our member states as they make these very tough choices in the path forward. We'll continue to cooperate very closely with the Council of Europe so that we can go forward in a strict complementarity. Thank you.
Merci beaucoup, Monsieur le Directeur, de cet éclairage de l'Union européenne et de votre agence. Ne pas sacrifier la qualité sur l'autel de l'efficacité, être attentif aux risques élevés qui sont posés par ces applications digitales et qui appellent de hautes garanties afin de préserver les droits fondamentaux. Et vous avez notamment insisté sur l'importance capitale de human oversight ainsi que sur la place, encore une fois, du justiciable. À notre propos introductif, l'humanité de la justice, tenir le manche du marteau, tout cela se tient. On parle d'humanité, fait spontanément penser au café, au droit au café. Nous sommes parfaitement en ligne avec le programme en ce qui concerne l'enchaînement des présentations, pas tout à fait en ce qui concerne le timing. Je voudrais donc vous inviter à présent à une pause. Nous sommes, vous l'avez vu, un petit peu en retard sur le programme. Nous voudrions reprendre à midi pile, s'il vous plaît. Donc je vous inviterai à revenir en salle un tout petit peu avant, peut-être 11h57, 11h58, et à 12h, on pourra reprendre après un bon café. Merci de votre attention aussi à chacune et chacun des intervenantes, intervenants de la première session.
I don't need a coffee because I had another 3 or 4, so if I have another one, I'll be flying. I will now introduce Mr. Dianis Bordas. He's the Deputy Prime Minister and Minister for Justice of Latvia, who will be giving us his presentation. And I thank him for coming, and I invite him to go to the podium.
Honorable Mr. Gurbanli, I mean, you know, after coffee break, it's hard everything to do very quickly, and I'm trying and doing my best. Mr. Justice Francesco De Pasquale, Dr. Jonathan Attard, Minister of Justice of Malta. If I saw somewhere, still is my colleague here. Ladies and gentlemen, members and Secretariat of CEPEJ. So I would I really enjoy all your hospitality. I started from very beginning at the table, but I saw this very excellent place and tribune. I also wanted to enjoy this feeling, and also to be made on videos and so. First, I would say that if we are talking regarding our digitalization, the one issue I think for all of us is coming in our mind. Digital world, even virtual world, it is forever, and it we will, and it changes, I think, the shape and attitude how we look on this. And the other thing is, I would like to say that the future is bright. In bad movies, fantastic is we are talking that virtual reality or AI will use people only for taking energy out of them. But in fact, we are using technologies, and technologies will help us to be free from work that must not be done by human beings. We will be free from work what is done by machines, and which can be done by machines. But we will use our brains and our intelligence, our passionate, each for other, for bringing justice, being not selfishness, being not like subjective in making decisions, and this is making our bright future. And then after this introduction, I wanted really to say and also from the very beginning, let me share heartfelt congratulations to all of us on 20th anniversary of CEPEJ. This is the main reason I think we came together here. And deepest appreciation and sincere gratitude to the CEPEJ community for over the years sharing the values of efficient and qualitative justice system. The example of CEPEJ represents the perfect tandem of cooperation to bring the targeted and practical to meet current and future justice challenges. To thank CEPEJ for your invaluable contribution in shaping the excellency of European justice system. Finding that you collect and share the best and useful practices and the different levels, for combining the academic, analytical and practical perspective in the most brilliant way. The work done by CEPEJ is at utmost value to access to justice and strengthening the human rights as the basic elements in the heart of the Council of Europe and the European states. And I wish you to continue this success for many more years to come. My sincere gratitude for the kind invitation to join the ceremony today. It is a great honor for me, especially considering close cooperation throughout past years established between Judiciary, Ministry of Justice and CEPEJ. Years full of great outcome, contributions and friendship. Anniversary and discussions today are an opportunity to reflect, take stock of inspiring achievements and to highlight priorities. The conversation on efficiency and quality of justice is obviously now very much focused on digital perspective. Emerging digital solutions has a strong potential to enhance access to law and justice. As one of the responsible for the digitalization of Latvian justice system through past years, I appreciate this opportunity to share a couple of observations and challenging questions faced. At case management and daily work of the judicial institutions, cooperate different actors and communication with parties could be streamlined and supported by technology. However, why the digital case, so-called, sometimes come with numbers of controversies, delays in implementation, different procedural and technical reflection to the conservatism, like digital skills, necessity to enhance cooperation between the different actors, in many opinions, doesn't provide much of help. In this perspective, I would like 2 points. Necessity to change mindset. A crucial aspect of digitalization, the work of the... I think that we need to elaborate most practical perspective. We all agree that most of our laws, procedures are not directly suitable for the digital world. However, we continue to try to put them as the basis in building the digital path. Of examples, know-how and methods how to make it different in building case management in the new digital perspective would be very useful in the current digitalization. Our opinion on how the digital case should be built is often based on a number of elements and views impacted by professional background and our experience. None of the involved is an impartial, and it would be useful qualitative analysis based on the hard data as regards the link between the introduction of different elements of digital case and the efficiency and quality of the procedure. Secondly, the priority remains on people centricity, digitally enabled, people-centered legal and justice services. No risks that the digital offering is not in line with fundamental guarantees. Pandemic created a turning point for the digital justice. Quality of the e-evidences and previous efforts in development of e-justice ensured that in general we were able to judicial services without substantial delay. In some cases, institutional and regulatory barriers were effectively reduced and technology processes not otherwise. Thus, I would like to invite us to look on the possibilities that the period of forced remote access provided to us. In 2022, e-evidences are associated with the access more than ever years before. This creates the momentum when e-devices could propose to be used to citizens for a wider range of e-services. Further development of the pre-trial online tools, possibility to obtain legal aid online, and state-provided platform for online dispute resolution would be helpful and widely demanded in the years to come and is an invaluable area of the CEPEJ to explore. For example, last year Latvia started broader discussion of ODR concept, with the focus on uncontested money claims and access to court for business. Thirdly, the power of data is not under the doubt. Institutions providing justice service and court are not only the place to solve the legal issue, but also in information hub. It's also information hub. Thus, if we are capable and able to use and analyze data, we could, at very much extent, prevent the conflicts and to deliver the information to justice problem in a more intensive, better way and thorough. Interconnection with the resources used by law enforcement agents, finance, economical, social and other sectors is obvious necessity. Let me also mention just a couple of words on the usage of AI. If digitalization is more about efficiency and speed, that IA is also about quality and judicial decision. Thus, the potential of IA to support legal analysis and research is undoubtable and practically to be used by judicial systems. I would like to mention one more field I see the potential of usage IA to be explored further. IA to support court management considering CEPEJ instruments. For example, in planning of judicial timeframes, weighting the complexity of the cases, predicting the caseload, and monitoring and evaluating the results of completed just forms. Let me stop here by wishing the next 20 years of CEPEJ work to be full of inspiration, innovation, and courage in the continuous efforts to strengthen court efficiency and boost an access to justice. Probably in another 20 years, the technology will be able not only to break the barrier between the courts and citizens, but also between jurisdiction and states, creating the base for full trust and mutual support of implementation and most effective approaches. Thank you very much.
Thank you very much for your positivity and your words. And I look forward to celebrate the 40th anniversary of CEPEJ when we will be over here all saying that, yes, you. So I will now invite Ms. Samia Chakri, Director of Studies, Cooperation, Modernization within the Ministry of Justice of the Kingdom of Morocco, to give us her contribution. Thank you.
Merci. Excellences, Messieurs les ministres de la Justice, Monsieur le Président de la Commission européenne pour l'efficacité de la justice, Monsieur le Président de la CEPEJ, Mesdames et Messieurs honorables intervenants, membres de la CEPEJ et représentants des délégations participantes. C'est un plaisir que j'assiste avec vous aujourd'hui à cette 38e réunion plénière de la CEPEJ qui coïncide avec la célébration du 20e anniversaire de création de cette prestigieuse commission, œuvrant depuis 2 décennies au perfectionnement du service public et de la justice et à l'amélioration de son rendement. En fait, les méthodologies et les outils de la CEPEJ ont prouvé une efficacité et une adaptabilité aux différents systèmes judiciaires. Notre royaume a pu en bénéficier depuis 2012. Dans le cadre des différents programmes Sud, 1, 2, 3 et 4, et aussi dans les autres programmes bilatéraux de la coopération. Je saisis également cette occasion pour adresser mes sincères remerciements au CEPEJ pour son implication sérieuse dans le processus d'accompagnement des réformes structurelles que nous engageons depuis des années au niveau de la modernisation du système judiciaire et du renforcement de sa gouvernance dans notre pays. Mesdames et messieurs, comme vous le savez tous, la justice est en perpétuelle évolution. Suite à quoi, les principes fondateurs et les mécanismes de son fonctionnement actuel doivent se conformer aux principes de bonne gouvernance, à l'état de droit et aux engagements internationaux ratifiés, afin d'assurer la transparence, la célérité des procédures administratives et judiciaires et l'efficacité du service public, afin de garantir un accès égal des citoyens à la justice. D'autant plus que nous sommes face à des mutations profondes des conceptions et des perceptions classiques de la justice et des modes de sa gestion. C'est perspective que le Royaume du Maroc s'est engagé positivement dans le plan national et international dans toutes les initiatives et projets qui font de la réforme de la justice un levier essentiel de développement. Mesdames et messieurs, une chose est sûre, l'amélioration de l'accès à la justice est la pierre angulaire de toute réforme du système judiciaire, particulièrement en cette période de crise sanitaire. De nouvelles exigences en termes de communication avec les justiciables et d'échanges dématérialisés auxiliaires de la justice. Néanmoins, cette démarche d'amélioration du système d'accueil et d'accès des citoyens aux services judiciaires ne peut être conforme aux règles de bonne gouvernance que si elle assure une action affirmative et sensible à l'égard de toutes les catégories de la société. C'est donc que notre département œuvre avec détermination pour promouvoir et appuyer les initiatives institutionnelles favorables à la transparence du système judiciaire dans sa globalité, à travers la nouvelle vision de la transformation numérique du système judiciaire, mise en place par notre ministère en parfaite action avec nos partenaires institutionnels et gouvernementaux, en tant que vecteur fondamental pour faciliter l'accès à l'information juridique et renforcer la transparence, l'efficacité et la célérité des services et procédures judiciaires. Cette nouvelle vision émane du ministère dans le pouvoir du levier du numérique, dans la démocratisation de l'accès à la justice, la performance des institutions et professions judiciaires, la garantie de la paix et le bien-être social. Cette vision de la transformation digitale se veut premièrement globale, intégrée et orientée vers l'usager. Ça veut dire orientée vers le justifiable, les auxiliaires de la justice, vers la société civile. Il doit prôner l'ouverture de la justice sur son environnement. Il doit s'imprégner de la méthode agile pour la concrétisation de ces axes et objectifs en planifiant des résultats itératifs et évolutifs en fonction des attentes des usagers cibles. Il doit reposer sur une approche participative impliquant toutes les parties prenantes de l'écosystème judiciaire en vue d'unifier les visions et accélérer la mise en œuvre des projets de la digitalisation. Enfin, il doit se décliner en services en ligne accessibles et inclusifs dont l'interopérabilité avec les partenaires est une des conditions incontournables pour réussir leur mise en œuvre. Mesdames et messieurs, à travers sa nouvelle vision de la transformation digitale, le ministère est plus que jamais déterminé de valoriser les acquis et de relever les défis identifiés à l'issue de l'évaluation des réalisations accumulées durant les 2 dernières décennies. Parlons des acquis, il y a lieu de rappeler que l'arsenal juridique au Maroc a connu une vraiment évolution notable pour encadrer tous les aspects liés à la transformation digitale. Je cite par exemple la loi sur l'échange des données juridiques, la loi sur la protection des données personnelles, la loi sur les services de confiance pour les fonds électroniques, la loi sur le droit de l'accès à l'information, la loi sur la simplification des procédures administratives et j'en passe. Également, plus de services électroniques ont été mis en ligne au profit des justiciables et des justiciaires. Toutefois, il convient de souligner que ces services ont été développés en silo, sans approche participative ni alignement stratégique. De plus, ils n'ont pas été conçus autour de l'usager. Ça veut dire qu'ils n'ont pas été centrés sur l'usager. Et de ce fait, n'ont pas réussi à réduire le parcours de ce dernier, ni à améliorer son expérience. Ce constat trouve son explication dans les lacunes et vides juridiques, vu la difficulté d'échanger le partage de l'information via des plateformes d'interopérabilité et de donner la valeur probante de ces échanges électroniques. Ce qui entrave la digestion de bout en bout des procédures judiciaires et d'autre part aussi l'absence de la gouvernance de la donnée au niveau des administrations, ils ont un peu ralenti ce chantier. Mesdames et messieurs, pour pallier à ces insuffisances et en capitalisant, le ministère a d'abord lancé une batterie de projets Quick Wins de digitalisation faciles à implémenter et en mesure de générer un grand impact sur les justices. J'en cite à titre d'exemple la mise en ligne de la plateforme de l'accès des femmes à la justice, les services de retrait des documents administratifs comme le casier judiciaire qui peut donner aux citoyens la possibilité de les récupérer par email, le service d'acquisition de la nationalité, le référentiel national électronique des métiers et professions juridiques, les plateformes des échanges avec les avocats et avec les autres auxiliaires de la justice, le dépôt et le suivi des réclamations en ligne, le développement d'une plateforme qui comporte des ressources numériques juridiques destinées aux chercheurs et aussi en général. Et j'en passe. Le ministère accélère sa cadence afin d'en asseoir les conditions, notamment sur le plan juridique. Le ministère est en train de préparer une loi sur la digitalisation des procédures il est en cours d'adoption. Aussi, le ministère travaille sur l'infrastructure numérique pour équiper les bâtiments et le personnel des tribunaux avec du matériel et de logiciels modernes qui peut suivre ce progrès de digitalisation. Aussi, on travaille sur la sécurité des systèmes d'information au niveau de nos lignes Internet et nos VPN avec les tribunaux. Aussi, le ministère travaille sur le capital humain. On travaille en montant en compétences, nos ressources humaines dans les tribunaux. Nous n'avons pas oublié aussi tout ce qui est organisationnel. Il y a eu un changement de l'organigramme du ministère pour s'aligner à cette transformation juridique. Et aussi, on a adopté dernièrement une loi sur l'organisation du système judiciaire qui va changer même les organigrammes au niveau des tribunaux pour faciliter cette action vers le digital. Nous travaillons aussi sur la fiabilité de la donnée. On a mis en place une gouvernance des données avec nos partenaires et il est intégré dans le nouveau organigramme du ministère. En parallèle avec la mise en œuvre de ces actions, le ministère mène un chantier qui constitue le fer de lance de la transformation digitale et qui concrétise la philosophie user-centric. Il s'agit de l'élaboration d'une cartographie de tous les processus judiciaires au niveau des tribunaux, en commençant par les parcours de l'usager, allant vers les processus et terminant par les manuels de procédure judiciaire pour prioriser les tests et les parcours qui ont le plus d'impact sur les gens qui viennent vers nous dans les tribunaux et faciliter leur relation avec les tribunaux. Aussi, on va réduire ce parcours de l'usager et on va permettre de statuer sur des priorités à inscrire dans notre feuille de route de la vision du ministère pour la transformation digitale de la justice. Parallèlement, un projet de loi pour l'usage des moyens technologiques dans les procédures judiciaires a également été préparé. Ce cadre légal ne porte pas uniquement sur le renforcement des garanties d'un procès équitable, en particulier à distance, mais sur la modernisation globale du système judiciaire marocain dans les objectifs sont la promotion de la gestion dématérialisée des procédures judiciaires entre les différentes juridictions du Royaume et le reste des acteurs du système judiciaire et le renforcement des mécanismes de justice à travers la numérisation des procédures. Aussi, il permet l'accès numérique des citoyens et les professionnels de la justice au service de nos tribunaux, l'utilisation de la technologie de communication à distance entre nous et les parties et tous les acteurs concernés. Mesdames et messieurs, il a été confirmé à travers les expériences antérieures du ministère de la Justice en matière d'élaboration et de mise en œuvre des programmes de coopération internationale que le succès n'est pas lié uniquement à la définition précise de nos besoins ou des domaines qui seront couvertes par la coopération, mais va au-delà et reste dépendant de la méthodologie qui sera adoptée, que ce soit dans l'élaboration ou la mise en œuvre de ces projets. Notre réunion aujourd'hui constitue donc un espace idéal d'échange d'idées et de bonnes pratiques en matière de digitalisation du système judiciaire et discuter des voies de coopération et des opportunités possibles en vue de soutenir et accompagner le projet de la transformation numérique de la justice par la CEPEJ. À cette fin, nous aspirons à instaurer une coopération basée sur les axes suivants. La conduite de changement dans la transformation numérique pour réhabiliter l'environnement du système judiciaire actuel afin d'intégrer l'utilisation de nouvelles technologies dans les processus de gestion et d'initier les procédures judiciaires et administratives. Deuxièmement, le développement d'un système normalisé des indicateurs de performance par type de dossier ou par type d'utilisateur qui vont faciliter la prise de décision à tous les niveaux. Troisièmement, le renforcement de la protection des données personnelles et le développement de l'archivage des registres et des documents judiciaires administratifs. Et quatrièmement, le renforcement des capacités humaines institutionnelles, législatives et réglementaires en soutenant les programmes de formation en matière de justice numérique et en accompagnant la création de nouveaux emplois génériques, en échangeant les expériences et pratiques législatives et réglementaires complémentaires avec certains pays leaders en la matière. En clôture, je peux vous assurer, mesdames et messieurs, que le ministère de la Justice, fidèle à ses engagements auprès des instances du CEPEJ, en particulier, ne manquera pas de mobiliser toutes ses énergies et de déployer un effort cohérent et global pour réaliser les objectifs de mise en place d'une justice numérique, tout en croyant fermement au solution Conseil de l'Europe avec lequel nous partageons les mêmes valeurs en faveur d'une justice accessible et plus efficiente. Je vous remercie pour votre attention.
I thank you very much for this run-through of a lot of things, and it's heartening to see that CEPEJ in some way has helped you out, and I look forward to having more things. At this stage, I will invite Mr. Duro Sessa, who is the President of the European Association of Judges and the former President of the Consultative Council of European Judges of the Council of Europe.
Thank you. Thank you, first, CEPEJ, for inviting us, and distinguished guests, dear colleagues. It is very difficult at this moment to say something which has not already been said, and so I will try to not to be too boring at this moment. I would like just to refer to Francisco said in the source of the heat is climate and feelings of the host. I would add one other source of heat, and that is the topic we are speaking today. Because it is controversial and everything, and sometimes frightening. I'm here in a dual role. First, as a President of the European Association of Judges, to perhaps say something how the judges are viewing this topic. And another issue is to speak something what CCJ already did in this field. I would divide this topic in two parts. First is information technologies. That is one issue, and artificial intelligence is another, and I believe something completely different. And what the justice is about? It is about who is delivering decisions and how are they delivered. So this is something which the governance in judiciary should go for, and indeed in that frame, all these new technologies should stay, because when we are speaking about information technology, it can bring case management, it can bring office technology, it can bring websites of different sources. They can be source of information in the case law, e-filing, distance hearings, and so on. But that is something which is only as something which will help judiciary to be efficient, to be quick, and to be in a time frames following the requirements of Article 6. So in this part, there are two issues I think very important. First, who is controlling the developments of IT? Is it in the control of judiciary and judges? Is it somewhere else? And Judge Reiling from the Netherlands once said that the IT technology is not a tool, it is an environment. And we are now in a stage when this is an environment where we are staying, and it is no way how it will get out of our lives. So the first issue is who is controlling it, and the other issue is financial, and that is how to maintain it. In 1995, there was the first steps of bringing new technologies to funded by the USAID. And one of the experts came and said, don't go there if you cannot maintain it. And that is, I think, a very big truth, because it is not going to be less costs, it is always going to be more costs than we can expect. So these are two issues which are very important. And this will bring also to another thing, and that is that we will change processes and laws. And that is another truth, that the judges are going to adjust to the IT technologies and not vice versa, even though we think that it vice versa. So this is something about IT. As artificial intelligence, of course, is something which is also in front of us, and bits of IG are saying that it will bring predictability to application of the law, consistency, they will prevent discrimination, and that is undoubtedly true. But again, I would like to stress, and I'm not going to repeat it here, what has been already said in CEPEJ in the ethical principles, these 5 rules which I think we should always have in mind when introducing different aspects of artificial intelligence in a court system. Because in the center is free and independent judge, and that is even it sounds like it sounds badly, but it is there for the citizens. So all these technologies should serve that independence judges and free judges, and not and so everything has to be designed into a way to facilitate the judges to do their mission, let's say so. Another part of my intervention is going to be about the Consultative Council of European Judges. In 2011, we delivered an opinion, information technology. At that time, I was also with the CCGA, and I was a little bit reluctant. Why are we taking this topic with all other very important topics which have been 11 years ago? But now when I read it, I can see that it has its relevance and stays, and what has been said there still stays. And that was the very beginning thinking about information technologies. So it is opinion number 14. And we are thinking about next year to deal again with this topic. So perhaps if it will be accepted at the General Assembly in November, we will deal next year again on some aspects of this topic. And Consultative Council has different values, if I may say. First, it is 22 years that we exist. Second is that sometimes we are in a nursery for the people who are going forward. For example, Muriel with the CCGA was now he's in Greco, so we are giving to the Council good officers for other Council of Europe bodies. In this opinion, what are the main topics? What were the main thoughts we said? First, that the IT should be a means to improve the administration of justice. Secondly, that justice is and should remain human and it deals with the people and their disputes. Thirdly, that IT must not diminish parties and procedural rights. Judges must be mindful of such risk as they are responsible for ensuring that parties' rights are protected. The use of access to justice as well as increases its efficiency and transparency. On the other hand, it requires major financial investments. Computerization can also improve the quality of judges' work, for example, through databases with links to judicial decisions, studies, and identical questions of law, legal commentaries, or previous decisions delivered by the court, and other forms of knowledge judges. And lastly, the use of IT should not, however, diminish procedural safeguards and should not even deprive the user of his or her rights to an adversarial hearing before the judge. Production of original evidence, to have witnesses or experts heard and present any material submission that he or she considers useful. And let me repeat once more, justice is not and should remain human as it is primarily deals with in their disputes. Thank you very much.
Thank you very much, Duro, for your words. You're right. The heat is not only as a result of our internal now the topic. The topic is very hot, but I'm hopeful from what I'm hearing that there are a lot of ideas. Now, I will introduce you to Professor Joe Cantantaci. He's the head of the Department of Information Policy and Governance within the Faculty of Media at the University of Malta, and he was my lecturer.
Thank you. Thank you very much. It's an honor to be here, and it's always fun to celebrate a birthday. There are many reasons why I think that Malta is a particularly fitting place for celebrating, because contrary to what somebody said this morning, CEPEJ was not the first initiative of when it comes to legal data processing. In fact, Malta was actually one of the places in 1990, 32 years ago, the whole Ministry of Justice hosted Council of Europe's colloquy on AI and legal data processing in the courts. And the first one of that was held in Bonn, actually, in 1989. But it's nice to celebrate the birthday, but it's also good to remember about some of the hard work that lies ahead. Digital is, as you will remember, digitalized justice is one of the main subjects that we're supposed to focus on today. And let's test, shall we, right? How many judges and lawyers in the audience? Now, when I asked, Mr. Justice De Pasquale, when I asked Francesco, how many are there? He told me about 85. So how many of you can tell me when the first Council of Europe's recommendation on computers and law was? And how many, don't be shy to put your hands up. How many can explain to the others what's the difference between source code and object code? Come on. Ooh. And how many can tell us what an API is? And how many, we have at least 2 hands going up. And how many APIs are you likely to have used this morning, right? Because we have a problem. We have a problem, right? We have a problem in legal education across Europe and across the world, in spite of many efforts for more than 40 years, right? Because, and I'm sure all of you are familiar with the Council of Europe's recitals, right? Considering that, noting, having regard to, aware of. I think we should celebrate today by including a new one, right? Ignoring, right? Because ignoring the Council of Recommendations for the last 42 years has been what most of Europe has been busy not doing, right? Or doing. Depends which way you look at it. Because if you go on, and I checked, have you any guesses how many reviews we have for a Game of Thrones, right? Which some of you might have heard about. I did find on Amazon, right? Teaching, research, and training, the field of law and information technology. Recommendation R9215, adopted by the Committee of Ministers. And as of next year, no member of CEPEJ will be able to sit unless they can recite it backwards, right? But this was not the first one. That recommendation in 1992 was already talking about AI, ladies and gentlemen. First one. 1980, right? 1980. And how many countries have actually implemented these recommendations on teaching our lawyers and judges? One of the main sources of disappointment of the Minister of Justice having left us this morning, the Maltese Minister of Justice, because I couldn't scold him for not attending my classes on computers and law, right? Unlike Mr. Justice De Pasquale, who was a good student. Many years ago, there we are. But you see, right, in our department, we've been going for 34. We were one of the first departments, and I'm just saying this by way of information. I'm not bragging. I just wanted you to look at the two subjects we have on the second and third bullet points. Legal informatics, applications of information technology in the legal and criminal justice sectors, and legal implications. Since then, we've helped write software for police and intelligence services. We've done some of the earliest applications for image recognition for border control. We've reviewed the Council of Europe. We have actually co-authored most of the following recommendations, because Ambassador Schneider, if you're still out there, while I was a member for 5 years of the drafting group for the Cybercrime Convention, of course I am proud of the Budapest Convention, but there's actually a Council of Europe Convention which is even more famous and even more well-known around the world, and that's the Data Protection Convention, commonly known as Convention 108, right? Because while also, and here I'm going to start combining things a bit with legal instruments not only of the Council of Europe, but also of the EU, like the GDPR, right? I'm going to zip through these because you can go and see them happily on the internet. But one of the things we've done is build up very strong relationships with law enforcement to try and see some of the key things in criminal justice. Because one of the things that CEPEJ has been talking about and looking at, as we did, right? CJIJ, for those of you who are Council of Europe freaks, look at CJIJ, Comité Juridique and Juridique, right? To which I was appointed as Malta's first representative in 1986, right? So this is a subject coming a long time. And one of the things that we have been looking at is, for example, how can you transfer evidence in an efficient way from the prosecutor's office to the office, from the police to the police. And that's a subject on which we've been working with Interpol and Europol also for many years. We also have developed, this is one of the projects we've done trying to answer the question. In other words, training people in an interdisciplinary fashion. So where does it all fit in, ladies and gentlemen? What does a judge need to know? What does a prosecutor need to know? Over the past 36 years, we have seen the birth of this subdiscipline we today call technology law, which also includes cyber law, which includes digitalization and digital evidence, where today we talk about digital markets and competition law, competition policy and pro-competitive regulation. I just wanted to remind you that competition law does not exist in a vacuum. It exists in a growingly digital world where technology-driven laws must dovetail with other sets of technology-driven laws, right? Some of you may remember the Cambridge Analytica scandal, right? Where more than 87 million users were exposed to Facebook breach, which of course came from APIs, for those of you who are still interested in APIs, right? But I wanted to remind you very quickly what technology law has given us since '81, and obviously since I have 10-15 short on time, right? But last year, we marked more than 40 years of European technology law. We have the Convention on Data Protection, the EU on Data Protection, the Convention on Cybercrime, the E-Privacy Directive of 2001, the GDPR and the Police Directive. 2018, we saw Convention 108 being fully revamped despite the opposition, it versus one. Europe versus Russia. Russia objected. Russia is now out, right? So what should judges know? 27 of the 46 member states of the Council of Europe are all EU member states. But European law is wider than EU law. And there are still some areas, it's very important that I remind you, ladies and gentlemen, that even those of you who, like myself, are coming from an EU member state, that there are very important areas of European law which are not covered by EU law, which were not designed to be covered. National security is one of them. Yet, they are covered by the Council of Europe's Ireland, Malta, Germany, Austria. Each one of those countries cannot find, and the judges of those countries cannot find guidance in the GDPR because the GDPR was never designed to tackle this part of life, which is actually reserved under Article 4, subsection 2 of the Treaty of the Union, right? So we have to look elsewhere. So when a judge is faced with cases, example of digital surveillance, the answer is not in EU law, but it's primarily in Council of Europe law, right? Specifically Article 9 of Convention 108, Article 11 of Convention 108 plus, where I won't bore you with the details, but unless the surveillance is by the state in a digitalized state, right? It can only be done if provided for by the law, prévu par la loi, for the purposes of law enforcement, national security, financial security, and some other things which are added. And it must meet tests necessary in a democratic state. Not nice to have, must have. And it must be proportionate. But what's coming? The Digital Market Act, for those of us, and let's remember, even for those member states of the Council of Europe which are not member states of the EU, these laws will have enormous implications, enormous ones. I go to Australia and they ask these things. Never mind Switzerland, Norway, Morocco, Tunisia, and everybody else, right? Will the Digital Markets Act affect things? Yes. Can European judges afford not to know about the Digital Markets Act? No, right? And just over the past 2 months, the European Parliament Committee has endorsed the agreement with the Council about the digital. So it's coming. I think T3 sees it coming in, and by 2025, it will be in e-evidence. I'm lucky enough, together with some members in the room, thank you for that, together with the cooperation of the Association of European Criminal Bar Associations, we put on a project called e-evidence, which is one of those few projects which not only the Commission really liked, but which it refinanced together with the Codex, so we could achieve that smooth transition of evidence from the lawyer, the police, to the prosecutor, to the judge, and so on. Is it coming? Yes. When the politicians agree, right? It's there. If you look at I've just put those for those of you who are interested in the dates and the numbers, right? 20 says final, the draft, yes, if only, right? Whenever somebody shows me a final draft, I remind them of the GDPR, which has the record 4,222 amendments presented, right? And then talk to me about final, right? But this has been coming, right? And as you can see, I've put in a few headlines there to remind you, the controversy continues, even the trilogue, right? And while on the one hand, 15 March 2022, we get the Parliament has moved substantially towards the Council provision, right? We have the EBU together with at least 17 non-governmental organizations saying the Council must do more to reach a compromise, which is the polite way of saying don't try political pragmatism down the throats of people who still believe in some principles, right? E-privacy. Oh boy, this is another one, right? Because we're not there yet. We have been discussing this 5 years, right? Will it happen? Probably. When? Before CEPEJ's 25th birthday? I don't know. Let's meet and celebrate. But because where it's going, we think we know. When it gets there, or that we know yet, right? And today we've talked about the European approach to artificial intelligence. Oh boy, if only I could believe our politicians, with all respect to the politicians in the room, right? Because we're looking down at the region, we're discussing the regulation for AI, whether it applies to judges, police, or anybody else, really. We have articles about it, and look at this. We don't even have modesty about it. You know what we're saying? And this is not me, this is the Slovenian presidency when it had the presidency. EU's artificial law should serve as model across the globe. And CEPEJ, I trust, will discuss in more detail, because there's a lot to see there, right? But will it happen? Is there a chance, like GDPR, like Convention 108, like the Budapest Convention, influencing things around the globe? Really, yes, if it makes sense. But at this moment in time, we have to kick some sense into our politicians, and that is not an easy task, right? Insofar as surveillance, I'm going to go into this, because the UN, and I should know after 6 years as serving as the UN's first special rapporteur on privacy, the UN can't get its act together insofar as privacy and surveillance is concerned, right? It's not that some countries don't want to, but I have never seen so much fatigue. Today we talk about Ukraine fatigue. I have never seen so much fatigue over surveillance as I see in the UN, right? So it's not going to happen, not for now. I'd love it to happen, but it's not going to happen. Bottom line, ladies, gentlemen, colleagues, European agreements in 2022 are all about digital policy and competition law. We're getting there this year, especially with the Digital Markets Act and the Digital Act. Yesterday, as I pointed out, we got data protection, we got cybercrime, we got e-privacy, and tomorrow, as I've shown you, we're going to get electronic evidence, e-privacy, artificial intelligence, digital surveillance and oversight, yes, but largely from a Council of Europe perspective. Much more, so watch this space. Let's come back and join Francesco and others for the 25th, 30th, 40th birthdays, and hopefully we'll have more good news by then. Very much.
Thank you very much, Professor Kanatachi, for this very sombering but discussion. Very much. This gives me, I remember why I used to attend your lecture. They were always interesting. Now, I invite Francois Pacher to give us his presentation. Francois is a judge of the Geneva Court and president of the CEPEJ Qual, one of those who used to work incessantly in quality.
Mes chers collègues, je pense qu'à cette heure de la matinée, la sagesse commanderait de se taire. Je vais quand même dire quelques mots et je vais commencer sans respecter les règles de la bienséance ou de la politesse par le secrétariat. Ça fait 20 ans que le secrétariat est vraiment la colonne vertébrale. Et sans eux, nous ne serions pas ici, mais nous n'aurions pas fait tellement de travaux au cours de ces 20 années, et je tiens à les en remercier beaucoup. Je remercie toute l'aide qu'ils nous ont apportée pour concevoir ce qu'on a pu faire. Alors, j'aimerais vous dire qu'évidemment, à la fin de la matinée, on a l'impression que déjà tout a été dit, et il y aura des effets de l'accélération du temps grâce à les quelques notes que j'ai prises il y a quelques jours, je pourrais les jeter parce qu'elles sont déjà trop vieilles. J'aimerais quand même dire ce qui vient d'être dit à propos de la délinquance ou de la délinquance. Il y a quelques semaines, une usine du groupe Nestlé a reçu une demi-tonne de cocaïne. Le taux de cette cocaïne était très élevé et vous pouvez bien sûr imaginer toutes les plaisanteries sur les réseaux sociaux, les gens qui ont demandé dans quelle petite dosette cette cocaïne allait terminer, et ça permettre aux gens de se sentir plus robustes, plus alertes et plus plein d'énergie dans le cadre de leur travail. Mais cette petite histoire, elle prouve deux choses. La première, c'est que ces trafiquants de drogue n'avaient pas insisté au point, puisqu'ils ont perdu leur demi-tonne de cocaïne. L'autre aspect plus positif, grâce à la numérique processus et la numérisation des containers, ça permet très rapidement de savoir d'où venait le conteneur, où il avait été ouvert, fermé, chargé de cette marchandise qui était un petit peu pour des gens qui torréfient du café. Autre élément d'actualité dans un domaine tout différent, mais qui nous concerne, il y a quelque temps, une société s'est vantée d'avoir numérisé l'ensemble de l'œuvre de Shakespeare et d'avoir développé un programme qui permet de créer de nouvelles pièces à partir de ce thésaurus. Alors, c'est très intéressant de faire du Shakespeare maintenant. Le fait est que, en tout cas, cette société se vante que cela est possible. Et puis, la semaine dernière, vous avez sans doute suivi l'idée d'un ingénieur informaticien, une société dont le nom commence par G, finit par E et qui a 6 lettres. Cette société a résilié le contrat de travail avec ce monsieur, qu'il était sûr que le développé avait lui-même maintenant acquis une conscience et que ce programme de dialogue avait pris l'indépendance, et plus de répéter les phrases qu'on lui avait données, il dialoguait réellement avec ce concept. Tout cela pour dire que nous sommes dans un monde qui change rapidement. Et j'étais un tout petit peu désappointé après la matinée en disant mais nous sommes d'affreux conservateurs en fait. Ce que nous essayons d'expérimenter de faire, c'est de trouver une sorte de se retrouver avant même que soit apparu et se dire mais c'était tellement mieux avant, il y a beaucoup de dangers, il faut y pallier, etc. Au lieu de ce poste qui consisterait à dire quel usage pouvons-nous faire de progrès techniques. Alors je vois un premier usage possible. En français, il y a un engin qu'on a une pompe à vide, ça sert à faire du vide à l'intérieur de cette pompe. Et scientifique, c'est un klystron, n'est-ce pas? C'est une pompe à vide. Et je pense que nous pourrions consacrer la naissance d'un nouvel engin qui serait le logo, qui permettrait de créer automatiquement des discours. Plus besoin non seulement d'assister à la conférence, mais on pourrait préparer le discours pour faire. Bon, je vais essayer d'être sérieux et de me placer en non 22, mais en 2042. En 2042, ce sera le 40e anniversaire de la CEPEJ. Je ne sais pas si le secrétariat aura toujours action. Moi, en tout cas, je ne serai plus là. Mais les gens qui seront là au cours de cette conférence 42 essayeront des 20 années qui ont précédé. Donc, on est dans la tranche 2022-2042. Alors, il y a des choses qui auront fait totalement consensus, et puis d'autres, 42, quelques discussions. Qu'est-ce qui aura fait totalement consensus? C'est clairement la vidéoconférence, à tel point qu'on a créé un nouveau mot. Et pourquoi ça aura fait tellement consensus? Parce que c'est tellement plus pratique, c'est tellement plus efficace. Je vous rappelle, et on reste toujours dans le cadre de la CEPEJ, ce sont nos collègues du tribunal de Rovaniemi en Finlande qui sont les premiers à avoir développé des systèmes de visioconférence. Et tenez-vous bien, ils ont développé des systèmes de visioconférence parce qu'en Finlande, à cette époque-là, il faisait froid. Il y avait des rennes, il y avait beaucoup de neige, et en 42, eh bien, dans les rues, il y a des lions et il fait très chaud. Mais ils continuent quand même à faire des visioconférences parce que ça fonctionne beaucoup mieux. Et vous voyez qu'en fait, qu'il y a stick dans le progrès technique, c'est qu'on a pu l'employer au début du XXIe siècle pour lutter contre, et au milieu de ce siècle maintenant pour lutter contre la trop grande chaleur. Et puis, il y a un second événement qui nous aura dans le domaine du développement numérique, c'est le Covid. Alors, le Covid a eu plusieurs effets. Pour les messieurs, il y a une inattendue, c'est que vraiment, on n'avait pas grand-chose à dire au sujet de nos tenues. Eh bien, toute discussion pour savoir si vous être en séance avec ou sans cravate. Alors, je vous rassure, je n'ai pas perdu ma valise, donc c'est par un choix que je vous parle aujourd'hui de cravate. L'autre aspect positif du Covid, c'est qu'on s'est aperçu des travaux qui étaient totalement faisables à distance, qu'on pouvait très bien se parler à distance, qu'on pouvait travailler à plusieurs sans encombrer les routes et les transports publics, et qu'on pouvait aussi, en tant que magistrat, travailler plus efficacement grâce à la... Ça, c'est une chose qui, au cours des 20 années qui vont rouler maintenant devant nous, eh bien, sera totalement acquis. Je triste parce que j'avais participé à ces travaux. Nous avions longuement réfléchi au sein de sur ce que devait être le palais de justice idéal. Qu'est-ce qu'il fallait offrir dans un palais de justice pour que les justiciables et après les magistrats et leurs collaboratrices et collaborateurs s'y trouvent bien. Il n'y a plus de palais de justice. Autant vous le dire, il n'y a plus de palais, il n'y a plus de nécessité d'aller dans un palais de justice. Donc, il faut trouver d'autres de créer ou de recréer ce qui est la dignité d'un palais de justice lorsque ce lieu géographique, en quelque sorte, n'existe plus. Est-ce qu'il faut continuer à faire de l'habeas corpus comme au XIIIe siècle? Parce que c'est ce qu'on fait, en fait, dans la situation des barons anglais qui avaient tendance à piller leurs concitoyens. Et avant que ça devienne une arme contre le roi, c'était un baron. Les gens qui se défendaient contre les barons voulaient pouvoir être présentés à un juge. Mais en Angleterre, au XIIIe siècle, il n'y avait pas encore d'informatique. Et on peut se demander, il faut absolument continuer à penser que les barons anglais ou les rois qui ont suivi aient toujours habeas corpus, ça se faire de manière physique. Alors, bien sûr, je ne suis pas en train de vous chanter les vertus du progrès sans penser quelques précautions qu'il faut prendre. Il y a déjà maintenant, en 2022, beaucoup de pays qui ont pensé aux biais sociaux que peuvent entraîner l'utilisation de téléaudience. Et sur Internet, vous trouvez des petits films faits par les autorités britanniques qui permettent aux justiciables de se préparer en ce numérique et comme ça, sur peur qu'il peut avoir de tels engins. Et ces films sont très intéressants parce qu'ils ne posent pas de grands principes de ce que c'est qu'une procédure judiciaire spécifique à chaque des domaines de la justice civile. Ce que j'ai intéressant en lisant la littérature produite autour de ces films, c'est qu'on recommandait aux juges de faire empathie. Et c'est là que vous voyez que les qui ont prévalu jusqu'à maintenant, les juges, en fait, peuvent continuer à être importantes par la suite, puisque le juge électronique, si je me souviens aussi, doit continuer à faire preuve d'empathie, comme ces preuves d'empathie sont près de le 22. Il a été encore, je pense, d'assez bon ton ce matin de douter des preuves artificielles dans la résolution des conflits et de dire qu'elle était, à ce stade en tout cas, quasiment inutile. Alors, d'abord, permettez-moi, chose qui a posé Susskind, dont on a parlé ce matin, ce professeur anglais, c'est les gens, ils ne cherchent pas à avoir, les justiciables, ils ne cherchent pas à avoir des tribunaux, ils cherchent à ce qu'on leur donne leur litige. L'intelligence artificielle nous permet de résoudre plus rapidement les litiges, peu ou pas l'intervention humaine. En fait, on peut plutôt saluer ça. Et puis, je pense qu'il faut voir ces éléments dans la crée de l'intelligence artificielle. Il y a quelques années, on s'étonnait en fait qu'un programme d'échecs soit tellement bien développé qu'il permette les meilleurs joueurs. Puis après, il est venu l'époque où les systèmes informatiques jouaient au Go et battaient les meilleurs joueurs de Go. Et encore plus récemment, des systèmes qui gagnaient par faire un poker ce soir, même si nous sommes prêts pour faire un tournoi. Ce qui est très intéressant dans le poker, c'est que c'est un jeu où l'information est incomplète. Parce que vous avez la main de 5 joueurs et vous ne savez pas comment les cartes sont réparties. Et le système est assez fort pour battre les joueurs, alors que, ou bien des échecs, soit il a assimilé totalement les règles, soit il a assimilé un aussi grand nombre de parties qu'il est capable de gagner la partie suivante. Mais il faut se souvenir que, et donc par défaut, vous avez toujours l'info sur le joueur qui est en face de vous. Alors, l'avenir n'est pas forcément radieux et il y a un certain nombre de gens qui considèrent que nous avons discuté ce matin est en fait la manifestation d'un phénomène général qui est le déclin du droit. La catastrophe est pour demain. La notion de déclin du droit est mise en avant et développée par un célèbre juriste français qui est Georges Riepert. Et de manière récente, Georges Riepert voyait comme une des manifestations les plus évidentes du déclin du droit, le développement du droit public. Donc pour lui, il y avait le droit des sortes, le vrai droit, et puis une archine qui avançait, qui était celle du droit public, l'autonomie des éléments, l'autonomie des partis. Alors, d'une certaine manière, on peut dire qu'il avait raison, c'est que le droit a peut-être vraiment perdu de son importance relativement par rapport au droit public. Puis de manière assez amusante, il y a quelques années, le Conseil d'État français a publié un livre qui parle du déclin du droit public. Donc, en fait, visiblement, on aime bien, quand on est juge ou juriste, se dire que, comme j'ai dit, en avant et derrière, et qu'on va absolument aller plus mal. En 1942, ce que nous avons constaté, c'est que s'il y a quelque chose qui est décliné, vous me permettez de filer la métaphore, c'est étatique. C'est qu'en fait, le développement des instruments d'intelligence artificielle, c'est en quelque sorte de l'autonomie. Plus les personnes peuvent résoudre les litiges interpersonnels qu'ils ont à des systèmes automatiques, moins l'État a avance. Permettez-moi, et j'ai bientôt terminé, de vous donner un petit exemple. Lorsque j'ai appris le droit, il y a bien longtemps, le mariage est encore une institution. Pas un contrat, c'est une institution. Et il fallait nécessairement un juge pour mettre fin à la vie. X d'évolution du droit civil, en tout cas en Europe, nous ont montré qu'on est passé d'une approche institutionnelle. On rompt le contrat de mariage comme on change de provider en matière de plus en plus, on se pose la question de la légitimité de l'intervention du juge dans ce domaine. Je mets à part la question de la protection mineure, choses comme ça. Mais en fait, pour aller est-ce que j'ai besoin de me rattacher à un droit national pour mettre fin au mariage? Est-ce que je peux trouver dans d'autres solutions sans rattachement avec un droit national une solution qui veulent se séparer? En conclusion, ce que j'ai envie de vous dire, la loi ne fait plus la loi. Ou bien, si vous voulez, ne fera plus recette dans les années. On trouvera d'autres systèmes de régulation, systèmes qui reposeront peut-être moins sur le droit promulgué par les États, plus sur la recherche d'autonomie des partis, plus sur la volonté de trouver des solutions vraiment à leurs besoins. Donc pour moi, ni la justice numérique, ni l'intelligence artificielle ne sont ces monstres ici-là. On ne va pas vers la catastrophe, mais on va vers un monde différent. Et je pense qu'en 2042, on n'aura pas assez de inquiétudes, qu'on se réunit toujours à la CEPEJ parce qu'on est en retard, et que tout ce que j'ai pu donner comme prédiction, ce sera sans doute absolument pas réalisé. Merci de votre attention.
Thank you very much, François, for your very perspective to the issue. Now, At this stage, Mr. Jean-Paul Jean, the Honorable President of the Cour de Constitution in France, who was also a former President of GT Qual. I believe that we have his intervention, and I will invite for his intervention to start. Or else I keep looking at the television, one of the two.
Bonjour à tous. Eh bien, tout d'abord, je voudrais m'excuser d'être présent parmi vous. Je vais venir à Malte. Et au moment où je vous parle, je serai dans l'avion. Je serai dans l'avion Bénin pour l'ouverture et pour préparer le congrès de la JUCAF, l'association dont je suis secrétaire. J'ai 30 cours de cassation de 30 pays différents, dont la Tunisie, et je salue je sais, est à Malte aujourd'hui, et qui lui va venir nous rejoindre mardi, puisque le congrès que je vais préparer ouvre jeudi matin. Alors, effectivement, je crois être un des plus anciens au sein de la CEPEJ, avec Ebra Ardèche, qui, je sais, interviendra aussi en ligne. J'ai présidé ce groupe de travail depuis 2000. Et donc, je me suis permis, en discutant avec Muriel, de dire quelques très libres propos, un peu, dans vos interventions. Effectivement, est-ce qu'il faut changer l'acronyme de la CEPEJ, CEPEJ? Alors, il y a deux problèmes pour moi. Le premier, c'est la notion de CEPEJ, Commission européenne. Dès que à des magistrats, ils disent « Ah bon, c'est la Commission européenne ?» Non, c'est le Conseil de l'Europe. Donc ça, c'est un petit détail que vous connaissez depuis un certain nombre, depuis 20 ans en tout cas. Le deuxième, c'est la notion d'efficacité. La notion d'efficacité, c'est différent en français et en anglais, c'est aussi en anglais. L'efficacité est très différent en français puisque c'est le regard de l'investissement sur un objectif précis. Alors, en 2002, lorsque la CEPEJ a été créée, ça ne posait aucun problème. L'objectif était la charge de la Cour européenne des droits de l'homme et le non-respect par elle-même du délai raisonnable de l'article 6. Il fallait donc en améliorer le fonctionnement des systèmes judiciaires pour traiter le problème à sa racine. Et je crois que cette nécessité absolue d'améliorer les standards internationaux, l'organisation, le fonctionnement des tribunaux, c'est une réussite totale. Je crois à partir du rapport d'évaluation, les outils conçus, mis à disposition par la CEPEJ, notamment le groupe de travail avec Jacques Buller. Ce travail est remarquable. Mais le Conseil de l'Europe, ce sont aussi des contradictions. D'abord, un état de droit. Or, je crois qu'il y a une tendance depuis 30 ans, 20 ans, à la procéduralisation du droit en multipliant les garanties du et les recours. Alors, on veut en même temps, dans les principes appliqués de la Cour européenne des droits de l'homme, plus de procédures raccourcies. Comment résoudre cette contradiction? Très concrètement, en tant que praticien. Aujourd'hui, dans les dossiers de délinquance économique et financière notamment, les avocats spécialisés, qui sont les mieux rémunérés de la profession, utilisent toutes les arcanes, multiplient les recours et allongent d'autant plus tous ces délais. La digitalisation, les dossiers digitalisés permettent des recherches automatiques de nullité de procédure, par exemple, sur un arrêt de détention. Vous avez des logiciels d'intelligence artificielle qui permettent des recherches et des croisements multiples de données et de jurisprudence. Et à partir de ces recherches, alimenter des conclusions d'avocats de plus en plus volumineuses avec la multiplication des moyens de droit auxquels le juge devra nécessairement répondre sous peine de nullité. Sinon, les cours de cassation casseront non-réponse à conclusion. Alors, on constate, et tout ça est constaté, l'augmentation du copier-coller pour augmenter le volume des conclusions, ce qui permet d'avoir des honoraires et des entrées pour le client, bien entendu, et des multiples entrées pour le juge. On change totalement l'approche quantitative du travail par le nombre de dossiers qui est piégé dans les arcanes de la procédure. Donc les résultats, pour synthétiser, ce n'est pas le droit, c'est la procéduralisation du droit au détriment du fond. Il y a plus de droit procédural formel et sans justice. C'est vraiment une question de par-delà les images sur les grands procédures, ce que l'on suit dans le ou la juge, de plus en plus une femme, ou un un homme seul, une femme seule, face à son ordinateur. Et le développement du juge unique a été augmenté avec le Covid-19. Dans les groupes de travail, on a toujours eu deux cultures qui ont dialogué, se sont enrichies réciproquement. D'un côté, et c'est le but de la CEPEJ, de sa plénière, les représentants des ministères, les administrateurs, les statisticiens, les services d'inspection, le top-down, qui est légitimement intéressé prioritairement à l'amélioration de la productivité, de l'efficience, de l'organisation, des délais. Et la digitalisation devrait renforcer cet aspect. Et de l'autre, nous étions quelques-uns, une minorité, des praticiens du judiciaire. Je salue ici François Pécher, Simone Cress, quelques autres. De l'intérieur de la machine, nous étions aussi, bien sûr, sensibles, et nous sommes toujours, et ouverts à tous ces outils statistiques d'amélioration de la productivité. D'abord, intéressés par le fond, les conditions concrètes dans lesquelles se rend l'acte de juger, tout simplement ce qui donne sens à la justice. Alors, nous avons produit, depuis les essais de 2003, le rapport d'évaluation de l'annuel qui a intégré ces deux approches. D'une part, efficacité, et d'autre part, garantie de l'état de droit dans le travail du juge au service du justiciable avec l'usager des citoyens. Ce deuxième concept, nous l'avons groupé autour du thème de la qualité de la justice, avec un groupe de travail spécialisé sur cet aspect. Mais dans le rapport évaluation lui-même, ce rapport biannuel, j'avais réussi à faire introduire, je crois que c'est en 2010, un sous-titre, cité et qualité, et qui figurait sur la couverture de ce rapport biannuel. En 2020, dans le dernier rapport, le titre a disparu. Il ne reste plus que l'efficacité. Alors je sais, le groupe de qualité continue ça, il produit nombre de travaux pertinents, les enquêtes auprès des usagers, j'en sais quelque chose. Mais aujourd'hui, en 2022, des changements radicaux se passent dans les tribunaux avec ces phénomènes, je résume, accélérés par la digitalisation, le Covid-19, l'intelligence artificielle, et le juge est soumis à une multiplication. Le seul concept d'efficacité ne suffit plus. Et je pense qu'il est même contre-productif lorsqu'on s'adresse aujourd'hui aux juges et au personnel de greffe. Il peut même faire l'objet d'un phénomène de rejet. Exemple en France, un mouvement de révolte avec signature de plus sur leurs conditions de travail, la pression productiviste qui s'exerce sur eux, le burn-out. À l'ENM, il y a quelques semaines, j'ai rencontré de jeunes Italiens qui m'ont dit exactement la même chose. Le Conseil supérieur de la magistrature en France, il y a un mois, a relaxé une juge d'instruction poursuivie pour avoir traité un dossier important durant 3 années, en estimant que sa charge de travail ne lui permettait pas de le faire. Alors, pour respecter ici aussi mes 10 minutes de délai raisonnable, qui est octroyé, de conclure par un changement de contenu d'acronyme. Gardez CEPEJ, bien entendu, c'est comme Vuitton, c'est un acronyme, un label, qui possède une réputation mondiale reconnue. Il faut garder ce label. Est-ce qu'il faut rajouter Q, comme d'autres, CEPEJ, pour rajouter qualité, ou bien simplement systématiquement décliner CEPEJ, efficacité et qualité de la justice, et le mentionner partout, dont sur la page d'accueil du site, sur vos logos, etc. En tout cas, je crois qu'il faut veiller dans les travaux de la CEPEJ à intégrer une dimension fondamentale qui est la dimension well-being, dimension bien-être juge et greffier, comme vient de le traiter par exemple l'ONU-DC dans un très intéressant rapport. Pour toutes les affaires judiciaires, toutes les affaires qui nécessitent, il faut intégrer le temps du débat judiciaire contradictoire, l'oralité quand c'est nécessaire, la collégialité quand c'est nécessaire, afin que la décision judiciaire retrouve tout sens. On n'a pas à travailler seulement sur les process, mais aussi sur le contenu et le sens de la justice. Et en tout cas, dans tous les sous-titres et tous les titres, inclure efficacité et qualité. Mieux pour vous, je crois, c'est d'en discuter autour d'un verre, ce soir lors du dîner qui conclura entre amis la soirée de 7 ans à laquelle j'aurais participé et qui ont permis en tout cas tant de belles rencontres. Et merci à la CEPEJ d'avoir permis tout cela et longue vie à la CEPEJ.
I would like to thank Jean-Paul Jean, who I'm missing, known him and had the pleasure of having him here in 2009. Much food for thought with what he said. And now invite, definitely not least, Mr. Georg Steaua. He was president of CEPEJ between 2015 and 2018, and he's an endless source of energy and ideas, which we will try to master and limit within a short time.
I got your word. I got your word, Cesco, and it is even now more difficult than the speech of Director Flaherty before. He was standing between us and the coffee break. Now I'm delaying likely the lunch if I speak too long, so I will focus on the main ingredient. I was invited to reflect a little bit on behalf of all the former presidents of CEPEJ to speak where we came from, what it is, and to wrap this session up. When I was invited to say about 20 years of CEPEJ, I mean, I was feeling the old grandpa, and who is sitting on the family table only speaking about the past anymore because there is no future. And I'm glad that I feel still again that we have future to talk about as well. It's maybe not like the grandpa, but more than the traveler on time, a little bit stuck between future, which is definitely more sympathetic version and idea. But anyways, it is 20 years, and then I checked on internet, of course, what's happened 20 years ago when we are our endeavors, and I realized 2002 was the year when Justin Timberlake broke up with Britney Spears. Very wise, almost should be. And Michael Jackson was holding out his baby on the balcony in Berlin, which also reminds us about the court cases where you have to intervene to keep the best fortune for the kids. It was also the year where Switzerland joined the United Nations. Thank for this. It is, I thought, longer ago, but it is not. We introduced the euro, which we, in the meanwhile, are complete. And it was also that Queen Mom died, unfortunately, her very long and fulfilled life. Why I mentioned? Because all of these events, when I was reading it, I thought it is maximum 10 years ago. No, time was flying. And why is time flying? Because we are really doing this with intensity and spirit. And thanks, I almost put a compliment when I was coming in. Now here, it is the friendly Maltese people, obviously, because yesterday my cab driver, when I was going out in the evening, also was estimated, and he was saying, you gentlemen, you're just 43 something approximately. And I said, no, hold on. You have to add 10 years more. But it shows the kind of crazy hobby we have seems to keep us a little bit young. And when I speak about the crazy hobby, then I remind myself that someone from the outside is asking us what we're doing at CEPEJ. It is very much and very often combined with the question which usually I'm addressed once here. And maybe all of you, being active experts and members of working groups and other functions in this are used to. People usually ask once a year, beside your main job at CEPEJ, do you do something else? And then with astonishing and disappointment when I say, no, moment. Yeah, we have a main job, and then we have this crazy hobby, where after the job, take the last plane to go for dinner in Baku, because it is to meet people there. Or we fly to a workshop in Kiev, because it is to improve statistics. Things like that. It is to underline the motivation behind it, because I think it is very crucial if we talk about CEPEJ. We are crazy enough, we want to know, we want to dig in, we want to listen, we want to, and then develop everything. And we want to learn esteem and respect, and even in developing friendship. Something I'm very glad about. A lot of those who know me long time here became really good friends, even if we see each other only a few times a year in best case. The questions, if we are efficient, the agenda is addressing this question, if we think that how we can improve our efficiency. It's a little bit like this thing, the frogs, how to proceed with the swamps. A little bit more wet or a little bit drying out, because how could we speak about our own efficiency if it goes about the efficiency of the court? And thanks for all this the results, because this should likely we did some kind of good work, but it is also to remind us that even in the year 2000, heavily discussions internally about key performance indicators. I saw my esteemed colleague and friend Jean-Paul on the screen a few minutes ago, and I can remember this discussion as it was yesterday. Parts of us thought that diplomacy of Council of Europe will survive this if we start to measure the performance of justice and the courts itself. We proved ourselves wrong in this kind of fear, for God's sake, and we ended up with stories. Almost everybody is talking about the digitalization, which is great. But I have to remind ourselves, the only innocent bystander in the room is not with us anymore. This is Mr. Rupert Kefai, the artist, who reminded justice is not about digitalization as such. It may help us to procedure, it may help us to increase the access of justice, but it is not itself as such. This is something we should remember also our next 20 years. And as I speak about this kind of painting, and the Maltese friends gave us as some present, it is very, very nice to see that an artist, an outsider, is thinking that CEPEJ is presented best to young women. So we have the young spirit still here. We would also choose in some kind of old grumpy judges maybe. It would also fit to somebody who have the young spirit of young women, talking and communicating in trust, Lady Justice blindfolded, reflecting themselves by the mirror. This is a detail which I like very much, even if I thought before it is a glass of wine, which also would be an element of putting in the last drink you usually have. But I would like to finish with this allegory of let's keep this kind of young dynamic spirit. Let's not stop self-reflecting of what we are doing. The drink is then the story which comes with the lunch, and this is more or less also for me to coming to an end, not to separating us too much from the well-deserved break. Saying that I hope last few minutes I was talking that CEPEJ is not only some technocratic thing, CEPEJ is a personal thing. Yeah? So if you begin, if you're interested, if you're this, it is something you're attached personally, and this is not only me, this is of you I know, in your dedication and to our community, and usually we talk family, which is to thank all of us in the way and wishing us that, again and continuing the next 20 years. Thanks, Francesco.
Allow me to thank you all the persons who gave us very valid contributions. You are all a family, we are all a family, this is the CEPEJ family, and now the family needs to go to eat. So it is time for us to eat. Go upstairs and enjoy your view of the harbor. And that part of the family that still needs to think will come here again at 3 o'clock to start discussing then the plenary. But in the meantime, please enjoy yourselves. And once again, thank you to everyone. And let's just say happy birthday to CEPEJ for the 20th. Thank you.